Chris. Yes.
Pardon to mention, my lord. Item 28. I 6 for adjournment.
Item
28.
20
28.
28.
Hearing
2013 matter, sir.
Information number ନାହିଁ କିଛି
Huh?
ପାଟିବାକୁ ଲେଖା ହେଇଛି ଚିଠି ଲେଖା ହେଇଛି କଣ୍ଟ୍ରାକ୍ଟରେ ନାହିଁ
This is against conviction.
conviction 307 against ଆସୁ 2 weeks after ଆସୁ କଣ୍ଟ୍ରାକ୍ଟ କଲେ
It will be there in the board. Let us see. After 2 weeks, it will be taken up. No problem. It will be there on the board. We'll see. What was the age at the time of filing? 37.
କେତେ
It
ବୟସ
must be there. We'll see.
37
Note kar rakho. We'll not take it up. Let it be there only.
item 30.
item number 29 my lord
Yes.
on behalf of Mr. Ashok Das he has been operated my lord file separation he has undergone file separation your lordship may call this matter 2 weeks after
Why is it personal problem?
Item 15, my lord.
15. The old
Maybe
matters, please don't mention. So,
Maybe
15,
taken
huh? 2015.
in second week of August.
No.
My lord, I have to take instruction
No,
from my
these
client.
matters are pending since
File has
how
been
many
mis-
years?
File has been misplaced, my lord. And
Get the pen drive and it will
And
be.
I will get it, but I will take instruction from my client. For
You
that reason.
let it be. You first reconstruct. We'll see. You reconstruct the file. We'll see. What is the offense?
Offense 307, my lord.
307.
7. My lord.
We'll see if there is no material. We'll convert it to 323. What is the problem?
My lord, that is there, my lord. I will
So
take instruction.
reconstruct the file. We'll see.
First week of August, my lord.
Nine, don't say that first week of August. We know who knows till August what will happen. 2 weeks, okay. 2 weeks.
2 weeks, my lord. I will
Item-
be not available after.
You try. If it doesn't happen, then happen.
Item
Item 26, my lord.
Don't you think that the old matters? Don't you think that old matters dispose of, then your office is free?
No, my lord, the client is not in contact with me.
My lord is
Since
taking
long.
the trouble of
Disposing of. Otherwise, see, this is a trouble for you people also.
Justice Bhalla did, my lord now is.
item
Try
30.
finish up matter.
Item 26, my lord. Your lordship may ignore my appearance. My brief has been transferred, so your lordship may just ignore my appearance.
Vigilance.
You are for petitioner.
Appellant, petitioner.
What is this matter?
My lord, brief has been transferred, your lordship may ignore.
Somebody
my-
else is appearing.
Yes, my lord. Your
If
lordship-
somebody else is not appearing, then I'll appoint you as amicus in this matter.
As your lordship.
Let it be there.
I'll be grateful if your lordship appoints.
Yes. Of course.
Item 30, my lord. Item 30.
Note down it. If somebody doesn't appear, then he is amicus.
Item 30. 30, my lord.
33.
30. 30.
33 0.
30. 30.
Oh. Yes.
Here the
2013 again.
2024, my lord.
No, 30 na?
31, sir. 31.
Not 30.
31.
31.
24. What do you want?
Maybe in the board, in the weekly list, my lord. It may be added to weekly list.
The weekly list means it will go down. If you want to do
No.
it, let it be there.
No, I have not
I'll
received.
accommodate you, no
I
problem.
have not received the deposition copies. It will take some because last week only lordship has been pleased to grant.
But 2024 matter will go down.
Then taken up 1 week after.
Let it be after 1 week or after 2 weeks.
2 weeks, man.
After 2 weeks. So try and get it so that
Yes,
it
yes,
is
so that
at
I'll-
the top we can.
In the meanwhile, I'll collect the deposition copies.
Very well. 2
Oblige
weeks
me.
ago, huh? Yes.
Pardon, lordship. Item 115 and 176 of weekly list, your lordship. Tomorrow and day after tomorrow, I won't be available. So let it be. So let it be in the list in the next week.
Do you think that it will reach tomorrow?
Maybe your lord.
If it reaches, then I'll.
Yeah, 115. It may
Okay,
reach
it reaches,
tomorrow.
then no problem. If it reaches, we'll accommodate. No problem. There are many people, those who are in the queue to argue. No problem. Yes.
Your Lordship, weekly list item 164. We have already posted a letter to the petitioner because
164.
yes, Your Lordship, in the weekly list.
Which year is matter? Yes. Which year matter? Let's see. 64 weekly. Huh? 13 matter.
We have already posted a letter for to come in contact with the petitioner, but the petitioner has not yet
Then
reverted.
let it be there on the board. We'll
Yes,
see.
sir.
Okay. Let it be there on the board. When it reaches, tell me.
Yes, sir.
Okay.
All right.
212,
200.
serial number 212, may be taken up 2 p.m. today,
212.
Lordship.
What means?
Matter 2012,
212. Okay. Criminal appeal.
Lordship.
BJP for the other side. Eh? Madam, at 2 p.m. already there are two matters. If time permits, I am ready to do it, but subject to the other side get ready. They should
Tomorrow.
also get ready, na? They are also under pressure.
Tomorrow, Lordship, maybe.
Not tomorrow, man.
Tomorrow.
Next week, any day. Next
Tomorrow.
week.
Let it be there. You get ready. Let them.
Last occasion, Lordship, fixed 9th. That is done. Lordship, okay.
It's all right. You note it down.
Yes, ma'am.
Get ready. Whenever you are ready, you tell me so that I can take
Ma'am.
it. Okay. Yes. Supplementary one. Yes.
May I please your lordship?
Yes.
The petitioner is a accused, my lord. My lord, the petitioner and accused person are both brother-in-law and sister-in-law, my lord. They were and Bhaujo. My lord, annexure 1 is running page FR 15, my lord. As per annexure 2,
What are you challenging?
my genity, my lord, you may kindly see annexure 2, page 18, my lord.
Criminal MC, how it is?
My lord, and page 18.
One
You-
minute. How it is company?
Hmm. No.
Tied up matter.
Tied up, your lordship.
In criminal MC, there is no concept of tied up.
No, my lord, you may kindly see. I have.
No accused, only in the bail. 1 minute, sir.
Okay, your lordship. Obliged.
In the bail matter only tied up. In criminal MC, there is no tied up.
No,
Go to regular.
no, no.
Tied up, no, I can't take it up. Because, this is 482 petitions are assigned to some other court. I can't hear it.
All right, your lordship. You may. All right,
This matter is wrongly listed before this court. Before this court, as CRLMC matters are not assigned to.
my lord, let it be, my lord. Tomorrow, your lordship. That
I can't give direction on.
tomorrow.
Please the matter before the assigned bench, subject to the approval of the formal authority. Tomorrow.
Yes, obliged, your lordship.
Item 2, I pray for Passover, your lordship. My file with clerk has not come up.
Passover.
File has not got till now.
Why she know the
Just one Passover, your lordship.
okay, Passover.
Item C.
May I please?
The petitioner challenges the order under annexure 4 at page 34, rejecting his application.
3.
under
Annexure
sec-
4, huh?
Ma-
Yes.
At page 34,
Yes.
rejecting an application under section 457 of CRPC. My lord. Here the petitioner is the owner of a laptop, my lord. The case is against his parents, my lord, under section 13 to ready 13(1) of the PC Act, my lord.
Hmm.
And thereafter.
What
the-
are you doing?
Your lordship, kindly have a glance to page 31, paragraph number 3. Petitioner is working as a senior engineer execution in Messrs. KEC
You are
International.
not an
Limited.
accused. You are not an
Not accused. And the said laptop was the official laptop of the petitioner supplied by his employer.
Who is appearing?
My lord, senior is appearing, last occasion directed to obtain instruction.
Yes, sir.
In fact,
He's working.
no, in fact, his grievance is pinned with a particular laptop notes.
Hell is it?
But on that,
See, the problem with vigilance and CBI people is they go to somebody's house for reading. They pick up everything, including the undergarments also.
but the onus was on me to
How will you
establish.
justify?
the
He
le-
is working. He is working in a concern. It's official laptop.
my lords, I
And if you want to retrieve some data, retrieve it and give it.
Yes, that is my pay.
may I submit one thing, my lords?
Yes.
Page 35, my lords. I'll place you for lordship with the other instruction, my lords. Page 35, my lords, paragraph 3, my lords. That indicates that petitioner is the son of the principal accused.
Maybe.
In the house search, my
Father
lords,
may be,
ma'am,
father may be bad. But doesn't mean that may give me an accused.
the principal accused,
If you have evidence.
the laptop, the son's laptop was placed into service for other purpose. You will see the last 3 lines. The principal accused is in the habit of acquiring ill-gotten money, and that the accused was doing cryptocurrency business by using the said laptop. It is further contended that the father of the petitioner has made investment in 88 crypto wallets by using the seized laptop, and the said laptop went sent to cyber cell Cuttack for necessary examination. My lords, on that point, my lord, last occasion, the last bench, the honorable bench, my lord, guided me to obtain instruction, my lords. But I have to place that materials, my lord, to connect, to establish the nexus between this particular.
You take the data, who stops you? Take the data, give the laptop.
Yes, my lord. But that was put for this the cyber cell, my lord. I will just come back to your lordship within 1 day or 2 days, my lords. That whether that is feasible. That was also my suggestion to them. But
Take the data.
they say that
data you can take. Give the laptop back. It was under your this thing. You
Well,
have when have you taken the?
Since 2022, my lord.
22
lords, on that, my lord,
2
because
years you could not
yes.
retrieve the data.
No, in
September
fact, I
2000.
contacted him. He is correct, my lord. I have contacted the concerned authorities during
Okay, Friday.
March. I lost. Give me some 2-3 days. I'll come.
Friday,
Friday,
Monday,
Tuesday, my lord.
Tuesday. Okay. Tuesday.
Because it came from cyber cell. my
But
lord.
see,
I got your lordship.
advise your client, whatever data you have, you take the data, give the
Yes,
laptop.
that is my prayer. And unless that laptop was returned to me, I cannot join the company, nor I leave the company.
I know, but the data they can take it.
Yes,
Because that
No, in fact, for
laptop is being used by
Yes,
your
yes,
father for cryptocurrency business.
but that cannot be because software is loaded by the company. That cannot be.
Whatever, if they,
Yes, yes,
whatever
let
data
them-
they
let
want
them.
to take.
Yes, yes.
yeah, in fact, I have talked to them. Lord, say, in the meantime, I cannot change the date.
I expect that Tuesday will say that we are releasing.
I believe not. So they will accede to my request.
Otherwise, I give a direction unnecessary.
No, no, no.
Not
I'll
required.
come back. What their grievance, whatever may be, pertaining to the data.
Try to be, 2 years, 3 years, you are taking a laptop for examination, you are not retrieving unnecessary.
Yeah, because of intervention election, all these officers have been posted for election duty. I could not pursue this matter.
And wait Tuesday.
I'll come back to
Smile,
your lordship.
Smile.
Tuesday.
Smile and smile. Oblige me.
Yes.
These are 16 minutes.
Yes.
But if the petitioner challenges the petition under section 457, wherein his prayer for release of fund has been rejected by the learned court below lordship. Lordship, this person is suffering from urological and cardiological problem, for which he has requested to release the fund from his savings bank account, which was withdrawn from his GPF account.
You are an accused.
Yes, lordship. And the fund has been deposited in the account of his son, lordship, because it was withdrawn from the GPF and it was for the son's marriage, but his son's marriage broke. That's why it was deposited in his savings account to meet the future contingencies, for which his petition was rejected.
That is your bank account, you are an accused.
No, lordship, my son's bank account.
Okay.
He's also an accused in this matter, lordship.
Who is the applicant? Your son?
Ramesh Patel,
Yeah.
along with father and son are the applicant.
Both of them
Both.
are. No, account of Jyoti Prakash.
Yes, lordship. His-
Account of Jyoti
Jyoti
Prakash. You are
Prakash, he's the
seeking
son.
seeking release of Jyoti Prakash account.
Yes, lordship.
Yes.
That is at page 22.
Lords,
Column number
this is coming for the first time, Lord.
If you notice,
But I'll-
notation, let him file reply 1 week.
Yes. Obliged.
Just consider is because some
Ailing person, lordship.
Ailing person,
Suffering from
frequently.
urological and cardiological issues.
your father is suffering.
Yes, lordship.
Have you mentioned those things? in
Yes,
the
lordship. I have annexed those documents also, lordship.
And he will examine.
Yes, sir. Obliged.
His notice returnable to his.
Give it, please. Sir.
2 weeks, otherwise he can't get things, sir. Yes.
Item 5.
May I please, your lordship? Lordship, I am in custody since 6th of December 2023 for possessing 23 kg 70 gram of ganja.
Yes. 23 kg.
Yes,
20
ma'am.
grams of my lord.
Huh?
20 grams, my lord.
23
Brown.
Oh, sir,
brown.
23, my lord.
23 kg
kg.
ganja.
23 kg of ganja.
Ganja,
Yes,
my
lordship.
Okay. Co-accused granted bail.
Yes.
You are in custody since?
No, my lord, what happened in this case, my lord? This petition also granted well by your lordship, my lord. And with certain condition and criminal antecedent verified the trial court, my lord. While the trial court, my lord, verified the criminal antecedent, found that the petitioner involved in another similar type cases. For that reason, he has not
What?
granted.
Earlier, the previous counsel was conducting this case and he had no instruction regarding the criminal and past criminal antecedent of similar kind of nature.
That is Lalbagh PS case number 206 of 2000.
Lalbagh PS case number
21.
206.
And similar matter, my lord. For that, in
What
37
can we-
bar, my lord. As because 37 bar, since if the accused not commit similar type of offense, then the court grant bail. Here, my lord, he has again, my lord, committed similar type after release from jail. My lord.
I had granted you bail.
Yes, yes.
Yes, lordship.
Subject to condition that verification of the criminal antecedent.
What can be done?
Also, one criminal antecedent.
What is recovered in the other case?
Other case, my lord, there is no such criminal antecedent. For that reason, you are granted bail.
21.
No, no, he is involved in another case. You
My lord,
say.
my lord.
What is the quantity there?
Quantity not mentioned, only, my lord, the PS case, Lalbagh PS 206 of 2021 mentioned, my lord.
How will you get over the bar?
Lordship, earlier we had no instruction regarding criminal antecedent. That is why-
After 2
and
weeks,
co-
after 2 weeks, rakho dekho. Get the CD, we'll see.
Much of it rest.
Yes,
Item 6.
August second week or yes, 6. Let him stay for some time.
Item 6.
6, my lord. Modification of a condition, the file of 2017, my lord.
Condition.
Condition.
What
Modification of condition.
which condition is page number?
20,000, my lord, rupees, my lord. To servant security amount of satisfaction, my lord. And religion furnishing bail bond rupees 20,000 with local and father, mother, brother, and sister of the accused may be the security, my lord. That is the, my lord, the condition in the year 2017, my lord. Whether that is survived or not.
You might have gone out of.
Not be in custody, my lord, since 2017.
What we'll do is I'll dismiss in default. If necessary, he'll come and move application. None appears for the petitioner. The present petition is by way of present petitioner is seeking variation of bail condition imposed by the court below while while enlarging him on bail. None appears for the petitioner. None appears for the petitioner. Dismiss for non-petitioner.
Item 7.
7, my lord. State filed this case for cancellation bail, my lord. What happened when in this case, my lord? He has violated the terms and condition. Also, my lord, they are involved in some other cases, my lord. And bail by anticipated granted by this honorable court, my lord. Though it is a matter of 2017, but in fact, my lord, he has violated.
Now, I'll give you liberty to move appropriate application for imposing condition, any other condition.
A state case, the case of.
I'll just dispose it up, saying.
My lord.
Bail, when the bail was granted?
18/5/2017. This honorable court, my lord. Directed the petitioner. 18/5/2017.
Okay. Only one petitioner?
My lord. No, my lord. Here,
Oh,
my lord.
many of them?
Seven, my lord.
7 of them.
7, my lord. And they are also not involved, only not involved in cases, but similar other cases are also pending against them, my lord.
They must be in the custody.
Anticipatory, my lord.
No, in the other cases, they must be in the custody.
Notice down.
No, what I'll do is,
My lord.
I'll dispose it up with giving you liberty
My lord.
to move appropriate application of the court below for imposition of condition in view of their conduct.
But they have,
Where is the question of cancelling the bail?
they are directed to appear before the IO, my lord. Before the IO, and I will fix the term and condition, and is suppressing the fact that they are involved in other cases, my lord.
See, the problem would be
My lord.
2017 bail has been granted.
My lord.
7 people are there. If I issue notice, you will take another 1 year to serve them. And by that time, the trial is over.
What happened in this case, my lord? What happened? This one directed them to appear before the IO.
I know, I understand they
In the
were.
event of arrest, they shall be released. They went to the police station and assaulted the IO, my lord, and ransacked the my lord, other chair.
The problem you try to appreciate.
My lord.
You are correct, 100%.
My lord.
But for cancellation, I will have to issue notice.
What happened in this case, my lord? They have not, my lord, taken the opportunity, my lord, given to them. They simply went to the police station and not availed the, my lord, the order and should be order, my lord.
They must be in the custody then in some other case.
They have not been arrested.
Then I am issuing notice, but condition is you have to serve within 1 week.
My lord.
If you can't serve, then
Right.
I'll dismiss it. Okay, issue notice. Returnable, the committee, 22nd. 23rd, okay, 23rd. It is made clear that if service on the opposite parties are not completed by then the state has filed this present petition seeking cancellation of the bail granted by this court by order dated 18/5/2017 while allowing ABAPL number 2986 of 2017 on the ground that they have violated the condition imposed by this court.
Condition when they went to the police station and assaulted the IO.
The accused persons have assaulted the police when the APF before them appear before the police persons to compliance of the condition. We should notice to the respondent within 22 made clear that no further opportunity shall be given for selling the respondent and the matter will be heard on that day. Yeah. You try to serve them.
They have ransacked the entire outpost of pelter stone to the sub-inspector and the staffs of the police.
Item 8.
Yes. Eight. 22nd.
Item 8.
It is also, my lord, for the modification of the conditions.
Infructuous, my lord.
Yes, tell me.
My lord, matter has become infructuous.
Counsel for the petition. What is your name, madam? You have written.
My lord, on behalf of Mr. Biswajit Naik, my name is Shatabdi Samantray.
Shatabdi Samantray, on behalf of Biswajit Naik, counsel for the petitioner submits that the matter has become infructuous, dismissed as infructuous. Yes.
Item 9.
9 has become infructuous, my lord.
8 also, 9 also.
My lord.
Yes, same on.
Item 10.
Item 10.
This case was yesterday. Lordship.
Cancellation for bail.
No.
Lordship may impose any other condition.
What are the conditions you have violated?
He has threatened the informant.
Huh?
He has threatened the informant.
That Willard in 2022 January, I have released on bail. Thereafter, they lodged a FIR against me that I am threatening them. And that subsequent case was tried, and in that case, I was acquitted, Miller.
Okay.
Yes, Miller. I have filed the judgment copy in my objection, Miller.
What to do? The case which you have registered subsequently, in that case, he is acquitted.
Lordship may dispose of.
Yes. When was the bail granted?
In
17/1/2022.
22.
And when the FIR was lodged,
Mm.
this FIR was lodged on February 2020.
Yes, madam.
Okay. Shall I dispose it up?
Yes.
Right now. You are the informant.
Yes, ma'am.
The petitioner is the informant in PS Baliguda PS case number 116 of 2021. Opposite party applied for bail in the aforementioned case and declared court below by order dated 17/1/2022 enlarged him on bail with various conditions. By blatant violating the condition, the opposite party got involved by blatant violation of the condition. The opposite party got involved in subsequent cases. Therefore, the petitioner seeks cancellation of the bail. And counsel for the opposite party submits that after he was enlarged on bail on 17/1/2022, an FIR was lodged against him on 21/2/2020. And in the said case, he has already been acquitted. There is no other case pending against him. Taking into consideration the aforementioned, I am not inclined to cancel the bail granted by the court below. Yes. Next.
Item 11.
Item 11 on behalf of Madam Mahapatra, may kindly pass over.
Pass over. Yes, sir. You are there.
My lord.
Okay. Again,
Yesterday that matter was there because I was suffering some cold fever. For that reason, I could not be able to appear before Lordship.
Requested
I'm sorry.
to make a pass.
Pass over.
Cancellation bail. One thing, my lord, I have already narrated.
Mrs. Mahapatra was
Yes,
there.
ma'am.
Yes.
My
She just
friend was
requested me. she
in
is
louder
not-
voice saying so that this is a cancellation. This is a perfect case for cancellation bail. State should have been filed. Comptroller filed the case.
She
Because
just
unfortunately, I have filed the case.
she is on her leg.
Now you
kindly
think over
Nahi,
variation of any condition.
नहीं मु कंडीशन ऊपर भी किछ कहूनी गोटे छोटिया प्रोभर मु आर्थर कहितली रक्षक जदि भक्षक के ताको रखियो के
That's right.
बाड़ जदि खेत खाइबो आदर कोन हिची
My lord,
टेस्ट्यूड लेडिंग रखाला योर लॉर्डशिप काम अक्रॉस द पेपर एंड न्यूज मीडिया ऑलवेज दे हैव ravished the victim lady on the date fixed during course of investigation on the date fixed taking up the bail application.
That matter, your once had them, that are disposed of.
Two bail.
Mahapatra.
Two methods of disposal.
Quashing.
Yes,
Disposed of.
ma'am.
she is
That
on-
we can-
Dicey. That story is very dicey. I don't know whom to believe, whom not to believe. Everybody is
नहीं your lordship the
better leave it there.
नहीं मु तो सेति में छाड़ दवा पई चाहूतली 70 वर्ष लोक किंतु तार आरोगेंसी आ तार ये ताको जहां
But then we'll change some condition. You tell me what condition.
as your lordship pleases because my lord
What,
justice
Mr. Raghuda?
Hello.
Best would be to impose some condition. What are-
Letter.
कहीं तू
she is
कोई
on-
कैंसिलेशन
she-
करिया
she just requested me.
हाउ ठीक अछि गोटे
Letter come.
हां माय बापा आई गोटे जजमेंट मु आपन कतर कर 3 जजेस बेंच ऑफ द अपेक्स कोर्ट माय लॉर्ड जस्टिस रमण हैज guide settle the principle and decided the fact that is the same case and bail has been cancelled.
And she is also, what is her age?
70. That for that reason I am so liberal to that extent. But fact remains, she has been engaged for sexual assault by the other person, by the present petitioner.
And
जोटा चालीची अबिका
And
you
also
think of any condition to be, further condition to be imposed and
can I pray before your lordship?
Yes.
Because my sister is appearing on behalf of the opposite party. I am appearing for the petitioner. I have also anxiety to impose any condition. She is also say
what condition
that-
you think over?
but
and tell me.
it is
Mr.
left to the Mr. Ragada.
Mr.
He will
Ragada,
say
some
as
condition
independent.
will add some condition.
whether she will agree or not, my lord.
He may not agree what to do then.
If my lord, she will
May
come.
ki-
No, no,
kindly
independent
one
will-
person.
No, what I'll do is, otherwise I'll dispose it up and relegate them to go to the trial court for
Better, my lord,
suitably modify the
my lord,
condition.
disposable in presence of.
Yes, that's always.
हाँ सेटा खाली मो जजमेंट टाको लेखिके तू गोटे देता कोन को कंडीशन हबो इंडिपेंडेंटली को दिस इज अप टू योर लॉर्डशिप
That is a better idea.
हां मु कहली कारण मु कहले असुविधा हबो से कहले असुविधा मु तांको छाड़नतो से मते छाड़नतो इंडिपेंडेंटली मु छाड़ देली से कोन कहचन
He will give in writing whatever condition I will put it.
स्टेट काउंसिल फाइलिंग करे बदल मु फाइलिंग करछि आज नोटिस इशू करछि
Okay. Letter come.
I am obliged, Lordship. Can I pray before Lordship? If I could not be able to appear on 2 p.m., I have already left to your Lordship. Your Lordship.
Give the judgment to Mr. Ragoda. He is there to.
3 judges, man. 8 2022, Wali.
Leave that book with Mr. Ragoda. He'll give it. Yes.
Okay.
First item, the sole appellant died on 2016.
There are 2 items.
The second item also, my lord, appellant died in the year 2014.
My client died
an appropriate application.
25/4/2016.
You have moved application there.
No, I have not yet filed. Yesterday,
I'll await both the things. Whenever you want to move.
No, Lordships, here, my lord, the widow of the appellant, for the first item, wants to contest the case because, my lord,
Now, have you moved any application?
my lord, IN number 1298.
It's there, my lord. It's there on the
12?
board.
1298 of 2019.
Flag D, your lordship mechanism.
Okay.
Limitation application is there.
Son has filed, huh? Who is filing?
My lord, the widow.
Widow. Delay? How much delay?
My lord, died on within 13 days, 30 days limitation. My lord, 25/4/2016 is the date of death. In the she filed, my lord, 13/8/2019. Near about, my lord.
But do you have a good case on merit?
yes, my lord. Here the conviction based on the extrajudicial confession before a person who is neither related to any not related to the case. They say that the जबरदस्ती से ताठू कही कि नेले जे हाँ हमें वही सरकारी वही बिकुथुले बोली से
What are the offenses? अच्छा.
PC Act offenses.
PC Act.
PC Act, my lord.
1 year conviction.
So all are both are dismissed from the service, so my lord, because they are not getting any pension or any retirement benefit.
No, why I was thinking is, if you don't have a case on merit and limitation, I'll
On that
dismiss.
ground, your lordship.
Unnecessary, it will not
No, it
be,
is a
you
very,
know,
we have a case, my lord.
it will not be, you kind of, you know,
Stigma. Stigma.
My
It's
lord.
totally based on
any confiscation, anything is there?
no
my
confiscation, only extrajudicial confiscation. That's
No
all case.
confiscation, man.
Confiscation.
No confiscation.
Hmm?
No confiscation.
Confiscation. So why I leave it? Think over, I'll put it tomorrow. Think over.
Then next
On the
week,
ground of limitation, I'll dismiss.
I have to file a petition, let it in next
I,
week.
in your matter, I'll await it. Whenever you want to file it.
Let it come both the matter next week. By that time, I will file my petition, my lord.
So, आरो सप्ताह का-
So that's what your petitioner will also be barred by limitation.
Yes, my lord. Both.
So on the ground of limitation, I'll dismiss so that, you know, the stigma, the part is taken care of.
That will not stare at them.
Because my lord, after conviction, both were dismissed from the service.
No, what happened here,
You are
my lord,
aiming
so
at
far
the
as delay is
service benefit
concerned,
My
my lord,
Oh,
my
you're
lord,
aiming at service benefit also.
salary, pension, everything.
salary,
my lord.
pension, everything.
Everything now.
That has to be heard.
That has to be done.
No, so
You
far as
take steps.
Next week, let it come
Next
next
week, हम लोग ये दिखते हैं. Take steps. And see, I'll allow the application and hear you there and then.
Yes, my lord.
My lord.
Yes, my lord.
Get ready with
my lord, my lord, on merit.
2006 matter. Next week, देखिए लोग जी. 19th, huh?
19.
Come with the application. File
Before
the
that, we'll
application.
file. Before
I'll
that-
allow there and then and hear you on merits and whatever.
Yes, ma'am.
Okay.
Obliged.
Copy of the paper. will be-
Give the paperwork, get it ready. If you have paperwork, give.
No.
Ready. Paperwork, my lord, not.
Not yet.
Not paperwork is whatever revision petition, whatever you have, you give it.
Rebecca China.
He doesn't have any. And you,
My lord, I will give my lord the appeal memo along with the evidence.
no, LCR has come. Take the pen drive and
Yes, ma'am.
from here you can take it. Okay, get ready. 19
19.
with application. Yes.
Item 13.
I'll allow the application and hear you on merits. The same day. Yes.
Item 13.
Yes.
Hmm.
13.
Miscase has been filed at Flag C for early preparation of paper book.
2007, he was 60 years.
17, my lord. Yes, 2007, he was 16 years.
60.
Yes.
So now, let's see how much. You should have a special officer to count the age.
New software needs to be developed.
60 years. Survival.
77 years.
Which area? Who is the area? This is evidence.
Which area?
Bhubaneswar.
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 Right.
Bhubaneswar
SP,
division.
SP Bhubaneswar division.
SP Bhubaneswar division. Direction to well-being and wherever. Okay. Huh? 18.
Item 14.
In this case, the mediation was taken up
For the opposite word.
So that check amount.
Check amount.
Check, huh?
My lord.
It was sent for mediation, but the report has come, but flag D, no?
A report has come.
The petitioner could not appear because there was communication gap.
Pursuant to the order.
I'm short for time, so another date for mediation.
What is this?
My lord, I have appeared there.
I'm from the
Petitioner is.
I'm from the
Why have you not?
because he put, but he was not there at Burger. I contacted the company and they say another one mediation is over.
Check, what did you check amount?
75%.
Huh?
Very small number, 75.
75. Forget about mediation, you bring it, I'll pass it here. Huh? Because mediation, I have sent it to mediation.
Yes, madam.
This entire process went on and you didn't appear.
I have taken time because due to communication gap between the petitioner and I didn't appear.
You tell me now, finish it up. You don't need a big mediation here. Check amount is 78. You give the money, if you don't have the money, give it in 2 installments. I'll put it next week and come with the money. I'll cost it unnecessary.
Next Monday.
Monday?
Yes, sir.
15 Monday.
Yes,
But you come with the money.
Yes, definitely.
And we'll close it.
Yes,
ma'am.
Why a minute? See, the matter was referred to mediation by order dated 22/1/2024. The mediation mediation report has been placed on record. As per mediation report, since the parties have not appeared before the mediation center, the mediation become unsuccessful. Learned counsel for the parties submits that due to communication gap, they could not appear before the mediation center. Be that as it may, the parties are interested to settle the dispute and settle the dispute. Mr. Rautraj, Learned counsel for the petitioner submits that he would persuade his client to make good the payment of the check amount by next date of hearing, release the matter on Monday.
My lord, an IA has been filed in this matter for substitution of the opposite party.
Let him bring the check and you
Ma'am.
take it and give it. Draft, you get the draft.
God bless.
Monday.
16.
Suggest some MIK query. Yes, Mr. Raghuram. Suggest someone. Mr. Mahapatra is there. He come. The present matter is pending since 2015, when the matter was taken up for hearing on 4/7/2024. None appeared, and none appeared. It was adjourned to. It was adjourned in the interest of justice. None appears today. Therefore, Mr. Mahapatra Purananitya from Mahapatra, and then counsel who is present in the court is appointed as a magistrate to assist this court. Race is directed to supply the paper book of the case to the Mahapatra. Release the matter. When? Tomorrow, day after, when? Next week?
Not this week, Your Lordship. Tomorrow. No.
Next week, you tell me.
18th or 19th.
18th? 19th.
Item.
What is the offense?
406.
406?
That informant has taken loan of rupees 30,000 by mortgaging some gold ornament, 2 chains.
Convicted for the gold.
He has returned, but he has given that loan amount. But that gold chain was not returned by the accused. That is the case.
Convicted.
Conviction matter under section 406 for 2 years. Fine is 5,000.
Appellate court confirmed.
Yes, sir.
2 years.
2 years.
The gold chain worth?
Gold chain.
Worth how? What is the value of that gold chain?
Value, my lord, has not mentioned.
Huh?
Value has not mentioned, but he has stated that
incident is of 2010.
2010, madam.
2010. That time he was
31 years.
31 years.
2015, my lord, 31 years.
And he has prayed for PO also, which was turned down.
Yeah, yes, ma'am.
What we'll do is we'll grant the benefit of PO, increase the fine.
Right. That will be better.
Yes, Mr. Mahapatra. That you can it be done today or tomorrow, day after Friday?
Not this week, Your Lordship.
Okay. 19th?
19th.
19th.
Okay. Item 17.
Non appears defect number 2, therefore not taken. Defect number 2. Huh? Yes, you tell me one thing, if the defects are not cured in a revision petition, can't it be treated as a non-est filing?
It's a ground for dismissal. Because now the recent notification that if the defect will be not cured within 1 month, automatically it will be dismissed. Now, listen, what the case is of the year 2015.
15 defects are pointed out, not cured, none appear.
Your Lordship may, while adjourning the matter, ask the petitioner will remove defect within 7 days, otherwise without referring the matter to the bench.
No, I am thinking of something else. What I am saying, see, once you consider it, that he has filed a revision petition, and since it is arising out of a conviction, the court is duty bound to appoint someone and hear it.
And
Okay,
also
if it is pending before this court. If I'll take a view that it is a honest filing, then that means nothing is pending in this court. So therefore, amicus query is also not required to be
required.
in the cases where defects are not cured. I can consider it
If
saying that it is a honest filing.
if there are minor defects, then you also ignore this defect.
Minor defect I am ignoring, but here defect number 2, in 2016 it was pointed out. You throw the paper in the court and thereafter you just ignore it. And it is pending and it's burden on the court. And what is it?
Lordship may pass that peremptory order that if it will be not removed within 7 days.
The peremptory order means then I am entertaining the petition. Then I can't do it. I have to appoint a chemical.
Since it is a conviction
Once
matter,
I entertain a petition.
since it is
Because it's a conviction.
it is a conviction matter, for that reason it should be.
That's the reason. So if I consider it to be an honest filing, then he can file a fresh petition if you want. Explain the delay.
Other.
इसको मेरे को दे देना. I'll just see. Or write down. The present revision petition is filed by the petitioner challenging the judgment of appeal court. No? Judgment of the challenging the judgment and order dated 7/3/2015 passed by additional sessions Judge Hon'Ble in criminal appeal number 11 of 2013, whereby the the appellate court, while confirming the conviction recorded against the petitioner for offense under section 138 NI Act modified the sentence. The revision petition is pending since 2000, was presented before this court on 11/12/2015. The registry has pointed out the defects. When the matter was taken up by the court on 29/2/2016, none appeared for the petitioner, and the defects pointed out the registry has also not been cured. Not cured. Therefore, in my considered view, the present petition is the present revision petition is suffering. The present petition, present revision petition is to be treated as an honest filing. As such, the petition is dismissed. Okay, non-honest filing. That's what the petition is. Yes. Yes, next.
Item 19.
18th here. Yes.
May I please, Your Lordship?
Yes, madam.
For item, an IF for the correction of the cost title, Your Lordship. I have filed an IF for the correction of the cost title, Your Lordship. There is a typographical error where I've written Republic of India instead of State of Odisha Vigilance.
What have you written?
Republic of India, Your Lordship. By mistake, I've written Republic of India.
Come to the court, do it now, right now.
I'll be filing the consolidated cost title, Your Lordship.
You forget it, correct it here.
Okay, Your
Only to
Lordship.
change Republic of India by State of Orissa, you are this matter is pending since 2019.
No, Your Lordship, we have filed it in the year
2023.
2023.
1 year. only to write one
Mat-
sentence.
Matter was not listed, your lordship.
Anyway, you come to the court. Correct it here right now.
Oh, after lunch,
Okay.
I'll be there in the
After
court,
lunch
your
you
lordship.
come. Keep it.
Obliged.
My lord, she may be directed to serve a copy, my lord, because
If she will come on, then only let her come. And she has wrongly written Republic of India, it
Fine.
has to be State of Orissa. That's all.
my lord.
Let her come and correct it here and give a copy also to you. Yes.
Matter 20.
Many matters are pending for no reason. Yes.
May I please? My lords, the petition is challenging the order dated 12/12/2023 for the discharge petition rejected by the trial court.
Yes. 12/12.
12/12/2023.
Yes.
It's page number 20.
Next year.
Now, the petitioner
Where is that order?
order is page number 24, my lord.
Next year.
Annexer,
Hmm?
Annexer 1.
Yes.
Last occasion, notice has been issued to the opposite party number 3. It has been written because this FR has been registered in 2005. Now the 2024, he is not maybe residing. So he is the state of Odisha, may kind of delete that OP number 3.
I didn't follow you.
When OP number 3 is the informant from the state of Odisha. Notice has been issued to him and it has been written.
Notice was issued to State of Orissa.
Oh no, that's the informant. He is in.
Informant is respondent number 3.
Yes, my lord.
What do you want?
And to delete it, that notice has been written.
Okay. Notice. But what is the position? Charge has been framed or?
No, my lord. Charge has not been framed. Last occasion, he has adjourned to the 16th of July, and last chance is given, or else NBW will be issued. So for that, my lord.
So you have filed here the petition and you don't go there.
No.
NBW issued, so therefore.
No. I'm going there. I'm requested, but he has adjourned. Last chance is given.
When is the matter fixed?
16th of July.
So you let us list it after 16th July. The charge is from, it will be infructuous.
My lord, charge will be from, it will be, the case will be infructuous.
That's right.
So
notice has been issued, you have not served, what to do? What can I do?
That constitutional
awaiting service of notice on the opposite party number 3 district also. Undelivered notice returned. The postal undelivered notice on respondent number 3 written with an endorsement. What is this? Endorsement that addressee has left without notice and not living there. In view of the same, the petition is directed to addresses of the party number 3, once opposite party number 3, and furnish recusal to serve the opposite party number 3.
My lord, prosecution can be stay.
No question of stay.
Or the adjournment can be granted.
No. Simply, I will not do that. I am just simply adjourning it because you have to serve. Yes, next. Now this is the.
My lord,
10 minutes. Yes.
my lord, may charge once framed, this case will be.
There are options.
My
You
lord.
can file another revision or you can amend this also. Yes. Next.
21.
And I am for the petitioner on behalf of Mr. Das. I'm praying for adjournment. Keep it to tomorrow or Friday.
2012 matter, sir. Adjournments are not routine, you know.
My senior is unhealthy, so tomorrow or Friday?
See, lot of efforts are going on, this thing. The registry is taking out file, listing it, court time is also involved. So therefore you have to be ready. What is this matter is about? Yes, sir.
Against 125 proceeding, which has been allowed by the court below. Thereafter, he has filed the revision for enhancement. That has been rejected. This revision is not maintainable because revision already filed before the session judge. The
Already filed.
revision filed. Now again he has filed the revision. So it has to be appealed.
The revision is dismissed by the sessions court.
Yes.
Against revision, again revision.
Not maintainable. Not.
How will you justify, sir?
Annex 5 with the improved
125 proceeding allowed by the trial court. You file a revision before sessions court, rejected. Now you have preferred another revision petition. What is the amount awarded to you?
1,000. At the relevant time, it was 1,000. They are tribal people.
Now, revisional court has confirmed that.
Yes, ma'am.
Revision court has confirmed that. What is the arrears now?
No, I don't have any instruction. All of a sudden, this matter has been listed, so I don't have any instruction with regard to that.
2012 matter.
Nothing, tomorrow or Friday?
Tomorrow.
Mr. Das will.
Tomorrow. Nothing survives it. 1,000 maintenance granted by the trial court long back in 2011, 2010.
At least for tomorrow.
And just see how many years. Whether they are surviving or not, nobody knows. Tomorrow.
Bless.
It's made clear, counsel for the petitioner seeks an adjournment in the interest of justice, adjourn to tomorrow. It's made clear that no further adjournment shall be given and the matter will be taken up tomorrow. Matter will be taken up tomorrow for hearing. Yes, sir.
22.
Yeah, please, I am for the petitioner.
Yes.
But despite of repeated information not responding, your lordship. Came out 1,10,000. Trial court that means 2 lakhs. Subsequently in the appeal reduced to 1,10,000.
What is this? 138.
My lord.
You are the petitioner.
My lord.
Respond. So what do you want? You have to pay money. 2 courts convicted.
So my difficulty not responding the petitioner despite of repeated information, your lordship.
Land counsel for the petitioner submits that his client is not responding to his responding him. Therefore, he has no instruction. The present matter is pending since 2012. The proceeding is arising out of a complaint under section 138 NI Act. The petitioner has been convicted by the court below and confirmed by the appellate court. Therefore, he has filed the present petition. Since the matter is pending since 2012, and there is no instruction, in that view of the matter is dismissed. Yes.
23.
Let's say item number 23 bring for and short adjournment. Short adjournment. Let's say senior.
Adjournment short or long, I don't know, but 2013 matter.
Yes. Let's say senior will conduct the matter.
What is this matter first? Tell me.
It is a addition of check. Let's say
there are many matters which are unnecessarily pending, and routinely you are asking for adjournment. Arising out of what? 138.
Yes, Lord. 138 NI.
Check amount.
1 lakh.
You were convicted by the court in 2007.
2007.
And you that is confirmed by the appellate court in 2013.
Yes.
And this matter is pending since 2013 again. Check amount is
1 lakh 7,000.
Yes.
It's mockery.
Nine lakhs.
Take up 1 lakh.
No, no. That nine, yes, 1 lakh. I'm sorry.
1 lakh.
1 lakh.
And how much judicial time you are wasting? And the 138 proceedings should have be concluded within 6 months. 2007 till today, and you are asking for time. Right off.
May I pray for
present petition, no.
Passover, my lord?
1 minute. Passover, yes. Passover I can give.
Passover, my lord, after two.
No, nothing to it.
No.
I'll dismiss it.
No, my lords, I'm opposite party, my lord.
Maybe.
I'm opposing. My lords, I'm opposite party.
I'm
supporting
passing
your
it
lordship.
over, but.
Lordship, pass it over.
Passing it.
After launch, I'm not available.
Yes,
If your
no.
lordship may.
Passing over, pass.
Lordship.
138 matter.
Yes, my lord.
2007
Lordship may dispose
conviction.
of today itself.
2013 appeal confirm and revision is pending.
Yes.
1 lakh rupees. You have to have little respect to the court proceeding.
Lordship,
Don't take it so lightly.
Lordship, I am extremely sorry. I am opposite party. I am supporting lordship. My lord, I grant for your lordship. Lord, but after launch, I am not available. So that lordship, that is the lord.
After lunch, the court will come to your house.
No. Lords, I'm not. I'm going to some other. Lords, that is the doctors and only.
Your presence is not required.
Lord,
I'll decide it on my own.
Lordship.
Both of you may not come.
My lords, I'm beg apologize, lordship, and grateful.
It's all right. All right.
Great.
All right.
24.
This is also the same issue. 130. 379. $379, 30. Yes, sir. What is this matter?
My lord, this matter of 379, 34 IPC matter, convicted under section 379 and 34 IPC matter. And the prosecution examined my lord 5 witnesses, my lord. And the
What is the sentence?
My lord, 2 years, my lord.
Cash of 92,000 stolen.
My lord, 92,000. 92,000 that the material witnesses PW 1, 2, and 3, they are corroborated to each other, my lord.
2 years sentence, huh?
My lord. And that at the time of PI parade not conducted, but at the time of trial, the identifying witnesses identified the accused persons. Here, Rudra Narayana Patra is the petition.
Non-APS for the petitioner. In the interest of justice, adjourn the matter to 19th. 19th, it is made clear that on that day, if none appears for the petitioner, the court will proceed with the matter by appointing an amicus curiae to assist the court. Please on 19th.
No.
If nobody appears, then that day I appoint amicus curiae.
25.
Division is directed against the order filling charge.
It's for hearing. Just wait for 5 minutes. I'll come. You get ready.
25, I am appearing.
Yesterday night, he has served at 9 o'clock 2 paper books of about 700 to 800 pages. So unless I go through those, what documents he has filed, it is very difficult on my part to give reply. So what I am suggesting, if my learned friend argues today, it is a long matter, he will take some time. I will give my reply next week, Wednesday.
FIR charge sheets.
Hmm.
Yeah, we must have gone through those. Nothing more.
I don't know what you have filed.
Mainly FIR charge sheet, a charge and the one other document that
Let
That
us
is the
understand,
hard
let us understand the overall, what is the case first of all.
Yeah.
Then we will see. But he wants to mention something.
Madam, item number 23, madam, was pleased to adjourn to after lunch. And I will find is appearing for the other side. I'm told, madam, that.
You are for the petitioner.
Yes, I'm told during admission of the case, 1 lakh, they disputed that amount.
What I'll do is I'll simply dismiss it. And everything is will fall in line automatically.
Not
You paid the money, then they will not come.
They have received 1 lakh, which was the disputed amount, money involved in the case. What I am suggesting to my learned friend, and also I have been instructed by the local council there, that it will be sent to local Adalat, it can be disposed of.
What the petitioner says is not audible.
Yes, I will fix up a date. I will fix up a date.
No, I would, whatever this way, that way, we'll do it today. Because otherwise that judgment is there, a Supreme Court judgment, where it says that in the revision stage, if you settle, you would pay 25% of the check amount.
Check amount has already been paid.
1
lakh has already been paid.
Another 25,000 rupees you have to pay.
Yes, but if that will be.
Pay and finish it up, I'll close it here.
Taken up by the day after tomorrow.
Day after tomorrow.
By the
There. Okay. Pay and fix it.
Yes.
Pay 1 lakh check amount and 25% or 15%. Just check it up. That judge.
15%.
I think 15%. If it is in Supreme Court, it is 25%. And in the High Court, no, they settled, they created the slab.
Balance.
And which stage if you settle, what is the
here
and you pay if it is 15%.
Here itself I will instruct today, my lord.
15% pay 1,500, 15,000, finish it up.
Yes.
Okay. And if you don't take it, then I'll set aside the yes. Yes, sir.
Wait, please, Your Honor. This
Mr. Panigrahi, let us understand what is the case is about. I'll recommend it to you. No
Okay.
let the
big, this is such a big volume.
no, I have given some judgments that.
Yesterday 9 o'clock.
No, it is to scare the other side or scare
nothing much to scare.
Perhaps he wanted me to take adjournment.
No.
That is what.
My prima facie view is, if you are coming against the charge or cognizance, having so voluminous paper, it is better that you should go to the trial court. The trial court should deal with it.
The voluminous
And that volumes also your lordship cannot go through. There is no page marking, no index.
Bulk of it is the charge sheet.
What is the case? Let us get a idea about it.
This arises out of an allegation of illegal mining.
Okay.
One B.K. Mohanty was appointed as a lessee for Uliburu iron ore mines. And he was appointed in the year 1982. He executed the lease deed on 13/12/1983. It was leased for 20 years. Before expiry of the lease, he submitted an application to surrender that had not been accepted. He withdrew the application and he also applied for renewal of the lease. And at that stage, in the year 2003, he appointed this petitioner, the company of the petitioners, Mr. Sneopus Marketing Company, as his power of attorney holder. And by virtue of that power of attorney, the it is alleged that the petitioner has done mining there from 2004 to 2009. And in the year 2013, a vigilance inquiry was initiated. There was physical verification, and physical verification revealed that the petitioner has done mining outside the leasehold area on the lapsed mining lease area of one Jagdish Mishra and Uliburu Reserve Forest. So on that basis, the FIR was done, the investigation was there, and the charge sheet has been filed. In the court, the charges were framed on 5/6/2017. 17. I have filed this revision there immediately thereafter. Yeah.
The stay is operating.
No, no stay.
If the charges were framed long back, now trial might have been.
Yes,
proceeded.
yes, my lord, almost 50 witnesses have been examined.
So at this stage, what do you want?
My lord, your lordship will see how the learned special judge, the Supreme Court has time and again said that the court cannot act as a post office while framing charge. But I will satisfy your lordship that he has acted as a
What
post
are the
office.
charges against you?
Charges are, my lord, under section 13(2) of the Prevention of Corruption Act, 409, 420, 468, 471, 379,
All the sister sections.
411, and 120B IPC. These are charges.
You have been roped in under the aid of 120B.
All the charges have been framed under all these sections. Even 13(2), the court has framed charge against me. That is my grievance, that he has acted as a post office. Admittedly, in the charge sheet it is mentioned that I am a private person. And yet, the court has framed charge under section 13(2) of the Prevention of Corruption Act.
That is one of your grievances.
For 13(2), that is the main crux of the argument. Though, then
you have you prepared any written submission?
Yes, my lord, I have written submission. I agree.
Yes, Mr. Panigre, when do you want? You tell me. It needs a little
No,
time.
if your lordship's hears him, then your lordship may give me some time to give my reply. Because of those voluminous paper books filed, I have not gone through.
No, I'll not hear it in piecemeal basis. Whenever you are ready next week, you tell me so that I can hear both of you and.
All right, then next Wednesday will be convenient to your lordship. 18, 17 is a holiday, I am told.
It will be very difficult. It could be only on the 24th. It could only be on 24th.
Miller?
It could only be on 24th.
All right. I have no objection.
24th, you revise your written submission if you want, and circulate it in advance to him, and give all the judgments. Which
I've given all the judgments.
You got the written submission, sir? The other side's written submission?
Miller, I will rely on the documents already filed.
Are you going to file any written submission?
If your lordship like, I will file it. But I will rely on the very documents filed by him.
It's all right, but your judgment, see, he is relying upon certain judgment. You also, if you want to file, you can file.
Those judgment sheets your lordship may kindly see. Will your lordship get one copy of the judgment? No page mark, no indexing, 400 pages.
That is the reason I just saw it. They'll do it properly and give it. So that
You must take my copy also, do that.
No hurdle in between. Right on. Learned counsel for the parties have agreed that they would address this court on 24th this month. And meanwhile, they would file their written submissions well paginated along with relied upon judgment. These written submission to be filed before court shall be supplied supplied by shall be exchanged by the parties. Shall be exchanged by the party. Leaves the matter on 24th. It is made clear that no further adjournment shall be given.
I have already filed, my lord, that.
But there is no pagination and all. You please see that
Pagination we will do.
pagination and give
that-
after pagination, give it to them.
Okay.
And I it is made clear that no further adjournment shall be given.
Okay.
Yes, next.
26.
ଏଗୁଡ଼ା ଦେଇ ଦିଅନ୍ତୁ ଆପଣ ସେ ପେଜିନେସନ୍ କରିବେ ପେଜିନେସନ୍ କରିକି ତାକୁ yes
26.
My lord, in item 26, my Lawrence India, Mr. Amit Prasad Bose's name may be kindly ignored.
that has already been done, but what is this case? Let us see who is appearing for the
200, the complaint petition file under section 200 CRPC was dismissed.
complaint petition is dismissed.
Complaint under section 200 CRPC was rejected. At page 11.
Page 11.
Page 11 and 12 is the petition.
Yes.
The petition is at page 12. Complaint under section 200 CRPC, and that was rejected.
No steps were taken there also, here also.
And in fact,
who is the complainant here? Complainant is one Mr. Sannyasi.
Whistleblower.
Whistleblower.
And in fact, in this case, what I was going that for issuance of any orders for investigation under section 156(3).
I'll just dismiss it. Right on. What is your name, ma'am?
Devadipta Sahu.
Huh?
Devadipta Sahu. D. Sahu.
Devadipta Sahu, on behalf of Amit Bose, learned counsel for the petitioner, submits that the petitioner has taken back the file from their office, so they are not interested to appear in this matter. Next, none appears on behalf of the petitioner. Today. Today, this matter is arising out in this petition. Petitioner has assailed the order dated. Where is the order? Order dated
3/8/2018 at page 11.
3/8/2018. 3/8/2018 passed by the special judge vigilance.
Violence.
Nice. Special
Ganjam,
bracket B.
Barampur, Ganjam.
Barampur. In ICC case number 1/4/2018.
Whereby 200 CRPC petition was rejected. Complaint.
It appears the petitioner, being the informant, had filed a complaint under section 200 CRPC, but it was not subsequently it was not prosecuted. Therefore, the impugn order was passed. The impugn order reads as under. The complainant is absent on repeated calls. No steps taken on his behalf by his counsel. Hence, the complaint petition is dismissed.
And in this revision also.
Dismissed. Next, since there is no appearance on behalf of the petitioner, and Mr. Bose has withdrawn himself from this case, as the file has already been transferred. I'm not inclined to entertain this petition. According to dismissed, yes.
27.
27 may be taken next week. Because my lords, I have sought for present status of the case. Your lordship may take any day next week.
Status is, I got the telephone instruction that it was posted for framing of charge on 1st May 2023.
May
1st May?
1/5/2023.
No, nothing has happened. I have taken instruction and I have.
I'll put it next week.
Oh, yeah.
Next to next
My
week.
lord, my
next picture is for the 22-23 Land counsel for the petitioner seeks an adjournment to get instruction from his client. Please see matter.
28.
There is 28.
2 weeks time. Very fast. 2 weeks time.
No, what is this matter?
307 conviction.
307 conviction.
Conviction.
2 weeks. Yes, you have a petitioner. 2013 matter you should argue.
Party contractor
Is there anything there in the matter?
Malo?
Is there anything on merit you have a case?
Senior करता ना वो
You want to engage a senior?
नहीं.
Yes. I'll put it in the weekly list. Get ready. Weekly list. Yes.
Item 30.
29? 30. Yes, sir. Conviction and sentence. Mr. Samir Kumar Mishra, last time appeared. He is there online.
Item 30, Your Lordship.
Yes.
Item 30, Your Lordship, it's an petition against conviction, Your Lordship. I pray for some time to take instruction, Your Lordship. I'm unable to contact the client.
In the year 2012, he was 38 years old. Madam, this is a matter of 2013.
Yes, Your Lordship, that's why I'm not able to contact the client. I'm trying to send a letter, Your Lordship. I pray for 1 week time, Your Lordship.
See, 2013 to 2024, more than a decade, you are not able to contact. Within 1 week, what will you do?
I beg apology, Your Lordship.
I'll retain it in the list only. It will be on the board. You get the instruction. I'm not adjourning it. Okay. Once it goes out of the board, then you will forget it. Let it be there. Okay. Let it be
My lord, recently he was released on bail. Okay, that's true.
He's arguing in a bail matter. Let him continue with that. Okay. Okay. Makes sense. Let it be there on the board. Once adjourned, then it will never come. Yes. Yes.
Even your lordship may direct to list it in usual course. It is just the matter of
24.
Your lordship has admitted the sub item second on last Wednesday. On 3/7, your lordship admitted.
Okay.
So it
weekly.
It will be listed in the usual course.
Weekly list means usual course only. Go down.
List, I have called for the deposition copies and etc. 1 week after.
I'll put weekly list down the line. We'll see.
Yes, weekly list 1 week after.
Weekly 31, huh? Yes. Pass over, na?
Item 2.
Yes, pass over. Yes. Yes, sir.
This revision preferred by the present petitioner, Your Lordship, challenging the order passed by the Honorable Court below, where he prayed for discharge, Your Lordship.
Order dated?
Order dated 22/9/2023, page 65, Your Lordship.
65. Okay.
The background of the case is.
And who is appearing?
Vigilance, Your Lordship. The background, Your Lordship.
Charge has been framed or not?
That has not yet been framed. by law.
In fact, the case, page
On-
67 indicates that 1610 to
2023,
2023,
it was
framing of charge.
fixed for framing of charges.
In the absence,
Pardon, Your Lordship.
It was fixed for framing of charges. Charges has been framed?
Not yet framed, Your Lordship.
in the absence of any interim orders,
No, not yet framed.
Yes.
Nanemu instruction Navy.
Your Lordship. Annexure 1 starts from page 16, that is the FI, Your Lordship. Here, initially the case was registered under section 13.2 read with 13.1D, 409, 406, 120B of IPC, Your Lordship. There are 5 accused persons, FIR named 5 accused persons, Your Lordship. 1 and 2, they were the marketing inspector of Junagadh and Kollamunda DPC, Your Lordship. Marketing inspector in charge of purchasing officer.
I think you argued this matter.
Yes, Your Lordship.
So why it was urgent?
It was adjourned because
I didn't agree with you.
no.
My Lord Fed wanted to go deep into matters.
Your Lordship, particularly.
Obviously, he could not persuade.
Lordship inquired
And on that
why
day he
the
was
accused
waiting
number
for
2 was not being charge sheeted, where he was in the similar footing with accused number 1 in the FIR.
Just come to the charge sheet
And-
let us see what are the allegations against him. If something is made out, then you would face the trial and get out of the.
Yes,
let
Your
us
Lordship.
Hoggeswar Ponda.
In 2008 and 9, I was the purchasing officer for Junagadh DPC, Your Lordship. I purchased paddy. I handed over to the Balaji rice mill, Your Lordship. That was my duty, Your Lordship. There is no allegation regarding what I purchased from the farmer that I didn't deliver to the rice miller, or any corner from the farmer that was the paddy which I purchased that
But
was
I
not
thi-
being
I
paid.
think I formulated some questions for you.
Yes,
answer.
Your Lordship. Here the case arose because the miller, he didn't deliver the custom milling rice to the OSSC, Your Lordship. He didn't deliver the rice. That's why this case instituted, Your Lordship.
But you have, whatever you have procured from market, you have given
What
it
I
to
purchased, that I delivered. Lordship particularly asked me one question on the last occasion. What was the authority under which I purchased? I'm submitting 3 documents, Your Lordship.
These are the part of charge sheet.
Yes, sure. 3410, that it is mentioned in the FIR itself. 3410, that was mentioned in the FIR, Your Lordship. Your Lordship may peruse that Sri Surya Narayan Panigrahi, one, Your Lordship. He was designated as the enforcement officer for Balaji Agro Product Limited. Once I delivered the rice to the miller, it is the duty of the enforcement officer to ensure that miller should deliver the custom milling rice to the OSSC, Your Lordship. And second document, Your Lordship, 702.
No, Surya Narayan Panigrahi, HESO. Your next name is Hoggeswar Ponda.
Yes, Your Lordship. I was for another rice mill, that was Santosh Kumar Agrawal, Junagadh. The allegation is not regarding Junagadh, Your Lordship. The allegation regarding the Balaji Agro Product Limited, he didn't deliver the custom milling rice.
Right.
Next document, Your Lordship, 702. 702, that is 702 dated 18/5/2009. Page 2, Your Lordship, Junagadh, left hand side, Your Lordship. And in the 30, Your Lordship, Balaji Agro Product Limited. It continues up to 23, and in the right side margin, 24, 25, 26, 27, 28, 29, up to 30 was inserted, Your Lordship. In the Balaji Agro Product Limited, he was entitled, he was authorized to receive rice from Junagadh DPC. And as because I was working as the marketing inspector at the relevant time of purchasing paddy, I purchased paddy from the farmer. I delivered it to the Balaji Agro Product Limited, your lordship.
He in turn has not given it.
He in turn has not delivered the custom milling rice to the OSSC lordship. And what was there was one enforcement officer was deployed for that to take care of what the miller has done, whether he has delivered the rice or not. But, and your lordship may peruse next letter, which I obtained under RTI, your lordship, from the sub-collector office, Bhanipatna. That letter is 851 dated 4/6/2009, last page, your lordship. There, your lordship, Junagadh and Kalampur DPC, and serial number in the right side, serial number 3 and serial number 3. Junagadh also serial number 3, Kalampur serial. The Balaji Agro Product Limited.
Let us come to the charge sheet.
Yes, your lordship. Now, lordship, it's because the miller didn't deliver the custom milling rice, and the Surjana Panigi and Sibo Prasad Dora, those who were appointed as enforcement officer as well as divisional management manager, though they were found to be guilty, your lordship, but the Khogeshwar Ponda, his name was named in the charge sheet, your lordship. Though I didn't have any role to play.
Who was found guilty?
Though the prosecution during investigation, they didn't find any material against the present petitioner, your lordship, but in an illegal manner, your lordship, with all vague allegations, he filed the charge sheet, your lordship, and pursuant to that, I have filed the discharge petition before the court below, which was disposed of in a mechanical manner, your lordship. There was no ingredients against me regarding any charge, your lordship. There no ingredients of any offences attracted against the present petitioner, your lordship. And more of your lordship may peruse, I have been suspended from 27/7/2009 to 6/7/2010, your lordship. During this period, the miller was about to deliver the custom milling rice. And in this period, your lordship, I was not holding any public post, your lordship. So there was no occasion for me to ensure the delivery of custom milling rice by the miller to the OCSC lordship. And though the Balram Shetty, he was marketing in charge of DPC Kallamunda, your lordship, he too was an accused, but he was not being charge sheeted in this case, your lordship. And I stand in the similar and same footing of Balram Shetty, your lordship. My role was only limited to purchase of paddy from the farmer and deliver it to the miller, your lordship. There is no allegation from any corner that what I purchased that I didn't deliver, or the miller had disputed regarding non-receipt of any paddy, your lordship. No allegation regarding that.
Yes, Mr.
Lords, this revision is directed against.
He has 2 points.
2 points. I got the 2 points. One is that he has no complicity.
He has procured
and secondly, the
and supplied to Balaji. Balaji in turn has not given. He has nothing to do with that. First point. Second point,
that during
another guy, what is his name? What is that? Kalampur guy.
Korlamunda.
What is his name?
Balram Shetty, who is also similarly situated, and he has done the similar allegations are exact similar to him. He also procured and he is given to Balaji. If Balram is spared, he is not made an accused. Why this gentleman is made? These are the 2 points.
In fact, he has taken another point, that during suspension period, isn't it? Now, my lords, this revision is directed against an orders rejecting discharge application, my lord. And in my first submission before this on courts, my lords, the materials produced by the prosecution before the London Trial Court at the time of hearing of the discharge application disclose grave suspicions and the exact materials which reasonably connects the accused, the petitioner of lordship with the alleged offences, my lord, in a case of misappropriation and that too in hatching the conspiracy, my lord, is at 42, my lords. What he did, my lords, he entered in conspiracy with other two accused persons. They are the assistant section civil supply officer and the civil supply officers. Both are co-accused, my lords. And in the year 2008 and 9, during that particular period, this gentleman, this particular petitioner for lordship, my lord, who was the marketing inspector, he procured both from the Kharif products and from the Rabi products to the extent of 60 lakh 153 quintals of paddies, my lords. And my lords, if lordship turn to page 42, my lord, the third paragraph, my lord, of the charge sheet, my lords, the exact materials indicating his the complexity of the petition, my lords, is at the last page of the third paragraph. 40, page 42 of the charge sheet, the page 42 of lordship brief, my lords. The third paragraph, I'm placing, lords, the during that particular period of 2008 to 2009, he being the market officer, my lord, he procured so and so on paddy under two sessions, the Kharif session and the Rabi session. But in total, 60,153 quintals of paddies he procured, my lords, and he supplied. Lordship can turn to the skip the few lines and lordship come to the third lines, my lord. The Khagesar Pradhan in charge of Junagadh, Kalampur DPC arbitrarily delivered 24.596 quintals of paddy to Balaji Agriculture Products Plants, Kesarish, Junagadh, without the order of the collectors, violating the official notes, which are the on section 405, lords, the IPC, lords, regarding the 409, lords, the entrustment, and with regard to the violating the established procedures, lords, the violating the collector's orders, which is as per that the official norms, lords. He, without procuring the orders from the collectors, my lord, he delivered these things because he was working in handing gloves with the other two accused persons, my lord, to enable him to get the benefits to the extent of, lords, and enabling this particular miller, Mr. Jain Miller, Ramkumar Jain Miller, of that Balaji Agro Millers, he could misappropriate to the extent of 1,73,000.
What is the offense?
The offense is misappropriation,
non-delivery of the rice, milled rice by Balaji, or procuring and giving it to Balaji.
So far, he is completed. This is also a case under 120B IPC, 140, 406, 409, and read with 13.2 and 13.1 this species. And the 13.2 not only for himself, for enabling others also.
Now let us clear on facts. Law, I can understand. Clear on facts.
This is not a groundless Panda.
During KMS.
During KMS 2008-9.
In that paragraph, last 3 lines.
The Khageshwar Panda MI in charge of Junagadh, Kalampur DPC arbitrarily delivered 25,596.32 quintals of paddies to Balaji Agriculture Product Plants, Kishinga, that is quintal 15,901.32 of DPC Junagadh's quintals 8,000.
Then you are making out a case that the delivery itself is the.
This is a part of conspiracy, and conspiracy always has in secrecy, and for that, no direct evidence is expected, lords. That has to be procured from the circumstances, lords. That has to be informed. That has to be informed circumstances. This is not a case which can be construed as a groundless case, lord. And in fact, in the learning trial courts, orders cannot be rejected, their disapplication cannot be faulted with. But the simple reason, my lord, there is no scope for the learning trial court to go for a roving inquiry into the pros and cons of that care matters, to hold many trials, my lord, to ascertain the probative value of the materials and records, my lords. In fact, the materials produced by the prosecution unequivocally indicates the complicity of the petitioner and disclose grave suspicions, my lord. And there has a conspiracy, particularly in enabling or facilitating this particular another accused, Mr. Jain, my lords, who is the proprietor of the Balaji Agriculture, to gain the profits to the 62 crores, my lords. And in fact, and this was the booty most likely to have been shared with these 2 other accused persons, my lord. That possible can rule out, my lord. So there were 1,73,000 63, my lord. This was the misappropriated monies, and this was the loss to the government exchequer, my lords. That's what this is.
How many
the case.
accused are there?
I mean, 5 accused are there, my lord. But the main games placed by these two, my lord, the main games, my lords.
Four have been charged.
The main thing has been perpetuated, the offense has been perpetuated mainly by the civil supply officer, assistant civil officer, and the present petitioner. And the ground he is taking notes that during that particular period, I was in suspension. Look, that during the suspension, where we are posted, you are posted the same. The headquarters of the accused petitioner are fixed at the place of posting.
No, that is
At
wrong.
the place of posting, and that particular place where you created this kind of mess. And in fact, you has the conspiracy.
Madam, that was the
particular
wrong
is-
finding by the court below you.
No, no, that
That
is
was
a-
wrong finding. Your
That is a defense plea that can be raised at a in an appropriate time.
We are looking at the legality of.
I'm a person whether it's a
of the
case of
impugn.
absolutely
Let us see.
groundless or not.
Let us see
After suspension, I went with the headquarter, your lordship, at Bhawanipatna. And lordship,
And this is not a small
regarding
paltry amounts involved, a huge
without the
amount
order
of
of the collector,
a misappropriation of government.
I've handed-
1 crore
I've handed
76,000.
documents, your lordship. That was the by virtue of the collector order and district manager order.
These are very good grounds, but these are the defense ground at base can be constituted. And those
And I've been
defense
included on
defense
my
plea can be
120
raised
laws.
before the London trial court. It has to be put into a test by adducing evidence to that effect.
And-
But this is not a case where can be considered as groundless case, my lords. But this is a case where the grave suspicion emanating, my lords, with regard to the complicity of the petitioner. He was the person who was in charge of procuring, yes. He was a person who, without obtaining permission or for the competent authority, as per the rules or the regulation which invoke, my lords, and it's applied to that Mr. Jain, who is a proprietor of that particular ones, my lord. And in a clandestine manner, my lords, they did everything enabling this particular Mr. Jain to enrich, to unjust enrichment, I should say, misappropriation to the extent of 1 crore 76,000
Why
rupees.
you were suspended?
I mean,
Well, he's a
in
habitual.
different charge, your lordship.
That's
In a
true.
different
That's true.
department.
But he's in
You
the
are-
habit.
I think you are a very decorative officer.
Correct.
No, your lordship.
Correct, my lords.
Lordship may peruse. The FIR reveals.
Trial court has taken care of the
Everything.
entire.
Your lordship, the FIR reveals regarding the allegation of non-delivery of custom milling rights, your lordship.
And I have no objection if my learned friend raise all those points. Liberty is granted to him, my lords.
I'm giving you a liberty. These
Lordship,
documents were there part of-
Lordship may hear you.
I don't think you have a case.
Lordship may hear me for a moment, your
Yes,
lordship. The FIR was registered for non-delivery of custom milling rights by the miller.
Don't repeat. I understood it.
Yes, your lordship.
Any
And
judgment,
there is
anything?
no allegation. And without authority, I filed 2 documents before your lordship. Not the official documents I obtained under RTI. I have been authorized by the
So
collector.
these are the defenses you have. You can very well lead.
That was not taken consideration, your lordship. That was not taken consideration by the IO, though I have submitted all the documents
It
to
is
the
IO.
IO.
See, it is IO's prerogative. We can make out a case by
And only
tying up in some document. If we leave some document it to his
Because
plea.
there is a prima facie, there is no case against the present petitioner, your lordship. Though the petitioner stands in a similar footing with Balram Sethi, your lordship, he was not being charged sheeted and the petitioner was charged sheeted. And I have been entangled under 120p as per the prosecution case, your lordship. And the prosecution is silent. What conspiracy I made and with another or other accused persons, your lordship. And I've been suspended. During suspension, your lordship, I was not a public servant, your lordship. And the miller was about to deliver the custom milling rice during that period. How can I be liable for that? And there is no allegation from the miller that that he has not received any procured rice from me, your lordship. The prosecution never came with that allegation that I delivered the less quantity of what I purchased, or miller has disputed regarding the quantity. That is not the case of the prosecution. Because miller had didn't deliver the custom milling rice.
Do you have any judgment?
Yes, your lordship. I will give written notes of judgment, your lord.
Give it.
Written note along with all the citations.
I'll also make some with a judgment, my lord, that these grounds for defense, my lord. This plea had to be raised in the trial.
Yes.
That Vijay Kumar judgment.
इसको भी रख दो उसके साथ. And think over whether you invite findings at this stage.
Better take the leave and raise all those points.
Or leave it open for the trial court to deal with it.
It's beneficial for us.
Think over and tell me.
Item 11.
Yes, 11.
On the
Yeah, Mr. Das has entrusted the brief to Mr. Ragada.
He is my friend, my lord, classmate. What all the rest.
Yes.
Yes, my lord.
What condition? What condition? Yes.
Informant is not belong to the
They
family
don't
of the
make-
victim.
See,
ठीक
don't-
है क्या?
one
What?
minute,
Okay.
don't make me wiser. I have made up my mind.
No,
That I'll not cancel the bail, I'll put some condition.
No, ମୁଁ ଟିକେ ଆଜ୍ଞା କହିଦିଏ. The petitioner is more than 72 years.
That's the reason I'm.
ଟିକେ ଆଜ୍ଞା. And
If you make me wiser, then I may.
ଟିକେ ଆଜ୍ଞା. His sister is the president of that committee. The informant is the secretary. What are there before the trial court to reject the bail application of the petitioner? Well, there is no prevention on the part of the informant to appear before the trial court and raise objection.
What do you want?
ମୁଁ ଆଜ୍ଞା କହୁଛି ଯେ what ମାନେ
Cancel କରିବାକୁ କହୁଛୁ.
how illegally କଣ ଆଜ୍ଞା ଦେଲେ?
Do you want that your bail should be cancelled?
ଆଜ୍ଞା ସେଇଟା
I'm not cancelling. Why are you arguing?
ନାଇଁ condition ଟା ଆଜ୍ଞା ଥିଲା ମୁଁ କାହିଁ କହୁଛି?
To strike a balance, if some condition could be imposed. I'm not saying anything. I'm not imposing any condition. I am sending it to you to move application if necessary. The court will do it. Trial court will do it. I'm not cancelling. I'm making it very clear. No question of cancelling bail if the trial court gives.
ମତେ ଖାଲି ପଦଟେ କହିବାକୁ ଦିଅନ୍ତୁ. ଟ୍ରାଏଲ କୋର୍ଟ ଯେତେବେଳେ ବେଲ୍ ଟା ଦେଲେ ସେଟା କଣ୍ଡିସନ କଲେ ଯେ ଇନଭେଷ୍ଟିଗେଟିଂ ଅଫିସର ପାଖରେ ଯାଇ ଆପିୟର କରିବ.
You appeared.
ମୁଁ ଆଜ୍ଞା ଆପିୟର କରି ଚାଲିଛି ସେମାନେ ଚାର୍ଜସିଟ୍ ଏପର୍ଯ୍ୟନ୍ତ ଦଉନାହାନ୍ତି ଫର ହ୍ୱିଚ୍ ମ୍ୟାଟର ଆଇ ହାଭ୍ ଅଲସୋ ଫାଇଲ୍ଡ ଏ ପିଟିସନ. ଚାର୍ଜସିଟ୍ ଏପର୍ଯ୍ୟନ୍ତ ପୋଲିସ ଦଉନି. ତ ମୁଁ ଆଜ୍ଞା କଣ୍ଡିସନକୁ ଓବେ କରିକି ମୁଁ ଯାଇକିରି 72 ବର୍ଷର ବୁଢା ମୁଁ ଯାଇକି ସବୁ ଇଏରେ ଆପିୟର କରୁଛି ବିଫୋର ଦି investigating officer, madam. And for that reason, madam, I have also filed an application against police charge. Sita to investigation sari kire.
Yes, Mr. Charge sheet. Why you are not filing charge sheet?
Charge sheet again. Di वर्ष हेलानी charge sheet seven do ना. 3 वर्ष हेलानी. Occurrence टा again होची. Your lordship will can see the occurrence.
Right. The informant in the petitioner is the informant.
21 occurrence.
Petitioner is the informant, na?
Again.
Petitioner is the informant in PS Kendrapada. नहीं, Marsaghai. Marsaghai PS case number 183 of 2021. The opposite party number 2 has been enlarged on bail by the court below by the order dated 25/5/2020.
And your lordship will kindly see the condition.
The petitioner, 1 minute, the opposite party is elderly women, huh?
Elderly man, madam.
Man,
Again.
Jagannath Tripathi, and he is 70 years of age. The petitioner seeks cancellation of his bail on various grounds. I am not inclined to cancel the bail granted, the concession of bail granted by the court below. However, taking into consideration the averment made in the petition, the petitioner is given liberty to move appropriate application before the court below.
If there is any
variation of any condition, for variation or modification of any condition to be imposed by the court below. If such application is moved, the same shall be considered on its own merit. You argue whatever. What all conditions are imposed. You don't file charge sheet. What else you need?
ସେଇଥିରେ ଆଉ ଟିକେ ଦିଅନ୍ତୁ ଟିକେ ଚାର୍ଜ ସିଟ୍ ଟା ଫାଇଲ କରନ୍ତୁ.
Rightly, my senior manager.
In his bail application for cancellation, you want relief.
Rightly, my lord.
ଆଜ୍ଞା 482 ରେ ଆଜ୍ଞା ଭଗବାନ ଆପଣଙ୍କୁ ଏତେ ପାୱାର ଦେଇଛନ୍ତି
482 439 2 ରେ application.
inherent ଆଜ୍ଞା inherent with every high court judge.
Item.
You file charge sheet. See, this is the story is completely dicey. Who is involved? He filed a quashing. I dismiss it.
ଆଜ୍ଞା
I dismiss it because so
later.
by dicey story. Yes, the girl is being utilized by. I don't.
ଦି ଜଣଙ୍କ ପାଖେ
That is the case.
The girl is ultimately the girl is the victim, and everybody is involved. The informant, the everybody.
accuse ସମସ୍ତେ
In true sense, I tell you, the poor girl is being used by the informant as well as the accusers to settle their own score. This is the story.
Item.
That is the reason police is not able to file the
Charge sheet.
Police is also under pressure.
ପ୍ରେସର ହଉଛି ଇନଫର୍ମାଣ୍ଟ
Why? I don't know whether you are pressurizing the other side.
ଆମେ ତ ଆଜ୍ଞା କହୁଛେ ଚାର୍ଜ ସିଟ୍
At the end of the day, only the victim is the first victim is the girl, and second victim is the police.
ନାଇଁ your
Because
lordship
they have to strike a balance between you and.
ଆଜ୍ଞା ମୁଁ ତ କହୁଛି ଆଜ୍ଞା ଚାର୍ଜ ସିଟ୍ ଟା ଦଉ ଫାଇନାଲ ଫର୍ମ ଦବାକୁ କହୁନି
That is what
ଚାର୍ଜ ସିଟ୍ ଟା ଦଉ
charge sheet. I don't know. They might be trying to find out the role of the informant also. Informant is also involved in this case. Informant is also involved in. These NGO guys are creating a lot of problems. They're using this kind of
Platform.
destitute girls.
Yes.
And trying to hype it.
Yes.
So that they get funds.
Yes.
And ultimately the victim is the victim will remain victim only.
Yes.
The victim is not going to get anything. And these people unnecessarily hype things so that they'll give a projection that we are doing so many things for the poor
Society.
girls and get funds from outside.
100% correct.
This is what is happening. What to do? Chalo, bail. And now why in this situation cancellation of bail? Yes.
Item 29.
That weekly list.
58
in weekly list.
Let us, we are proceeding now.
Yes.
Passover is over. Now weekly list. Na? Let us come to weekly list.
That's item 58, Lordship. I've discussed it with my learned senior.
Yes.
Let it come on 31st for final hearing at 2 p.m.
It will start from
2 p.m.
This 58 was also fixed for 2 p.m. today, Maharaj.
1 minute.
58, Maharaj.
8 1 minute.
So that can be taken up on 31st at 2 p.m. Maharaj.
He wants an accommodation that he has not.
Hey, the problem, I'll tell you, the problem is if you fix a particular
let it lie, let
2 p.m.
it continue in
and adjournment is short, then there is no other matter.
Then was
So I'll
31st.
fix it.
Okay, on 31st.
Because
Only on
once it is fixed time, you don't stick to that.
Maharaj, only on 31st, Lordship mentioned. 31st of July.
Two matters.
Yes.
Which call you are referring for?
I'm for the appellant, madam.
No,
In
there are
first
two
matter.
matters.
Yes.
Two
matters I am appealing.
He is only appearing. Yes, yes.
Because
So, adjourn it is a 2010 matter.
Yes.
yes, I'm ready, my lord. I am ready.
It is against charge or what?
No, it's
it is
an
a
appeal, conviction, appeal against conviction.
Conviction, but it's a case, very small matter. This is a private aided school. Some appointments were made in 87 before coming into the force of the new rule. They said that new rule says that the prior permission is required. The appointment may be irregular, but no criminality is there. And apart from that, they have not taken any salary. The persons who were appointed, they have not taken any salary from neither from the school nor from the government. There is no criminality, nothing is there, and nothing has been proved. And they have only discussed some case laws that has not been applicable to the case, and that is how they have been convicted. And more interestingly, when the charge sheet was filed, the school became a government school, my lord. Once it is become a government school, then a sanction has to be, my lord, there. There is no sanction also against the headmaster, my lord. He is an accused, he has been convicted. So that score alone, this has to go, my lord.
But the offense had taken place earlier.
Yes.
But it's
There's
said
the
that charge sheet, when
manipulation.
the charge sheet is filed,
At
that
time of taking cognizance.
yes, that time, my lord, the school has become government school. Then, my lord, sanction is required, my lord.
That's manipulation and forgery part is also there. My lords. And
So
that,
then you tell me when.
my lords, 31st, my lords. 31st. Yes.
Next week.
No, next week it's already packed. my
24
lords.
तारीख को हो, 24 तारीख.
31st, my lords. We'll dispose it upon Thursday. I will conclude my hearing.
Just see what.
Yes,
which
31st.
date will suit you.
My-
No, I have no problem. I am ready any
But
day.
he has to get ready na,
My
lot of
lords,
matters.
in fact,
He says 31st, I have, let it be then on that day, it should.
Yes, definitely.
Mr. Rijvi seeks an adjournment. Adjournment as a lot of other matters are lined up for hearing. Release the matter on 31st. Huh? It's made clear that no further.
Item 29.
Great. 20?
29 of the weekly list.
Yes, sir.
Yesterday's list, your lordship has directed me to serve a copy on state. Your lordship can.
2007 matter, yes.
Yes. Where not, I have no instruction whether the man is alive or is because at the time the case was filed, he was 55.
No,
Now
no. Just see, you see the trial court judgment.
Yes.
Because generally 41, 2007, he was 41.
2007, he was 41. But 2000,
No.
55.
I'll tell you, no, it's doubtful. 97, he was 41.
Yes.
See the trial court
Yes.
order.
In our brief, in High Court.
Where is, 1 minute, I'll just see from the charge sheet, 29, na? Charge sheet.
55. 2008 is 55.
This the age is also lost meaning after corona. You never know. Will you verify or I'll ask them to verify?
Your lordship, yesterday.
You also verify, let them, you do it.
Okay, the number.
Where from you?
Copy gote ଦେଇଛି ପୁରା କାଲି ଗୋଟେ copy ଦେଇଛି.
Criminal appeal, which division?
କାଲି ଯୋଉ copy ଟା solve କଲି ତା.
Range officer.
Item
vigilance. Barampur.
Yes.
Mr. EGB, Barampur. Barampur division. Huh?
It's copy of the order for compliance.
18th?
18th, yes.
18th.
The man.
And you also verify by that time. 18th, he will get.
I have verified from the telephone number what he has given at that
anyway,
time.
you try at your level, but he is
Yes.
getting the information. Yes.
I think he is now, at the time he has given the telephone number, he said he was staying at Puri. So local police, Puri and Brahmagiri.
If you don't have address, the entire Puri, they'll keep on searching.
There is an address. In the affidavit page, there is an address.
You give that address.
That I have given the copy. I have given the copy.
Mr. Rijvi will take care of
Yes.
that.
Item 57.
Last 15 to 18.
18.
Item 57. Weekly list.
57.
7, my lord. I copy of the paper book is lost somewhere. May I pray, my lord, the matter may remain in the list, but
It will remain, don't
it will
worry.
remain, but it may not
Yes,
be taken up.
whenever it comes, you tell me when the matter is called up.
Yes, my lord.
I recommend it, don't worry.
I will obtain a copy of the.
You get the pen drive and take it from here. I'm saying I am giving a standing in this thing, instruction to my staff. Whoever has lost the file, because it's a very old file, obviously, in the office, you might have lost it. Come with the pen drive, take the entire LCR and everything you take it. No problem. Don't go by the formality of applying and all. Don't waste time. Yes. And if you get it and give it to the other side also, a photocopy, so that it can be heard. Yes. And 2 o'clock we'll start. 18, no? Yes.
Pardon to mention, my lord. In item 19, your lordship is directed to change the cause title in the court itself.
Sorry, I didn't follow you. 19?
19.
What about?
The Republic of India will be changed to state.
You do it now.
Yeah.
Give, no, you do it. Wait, right. Yes, sir.
So this is a matter, Madam.
And
The
there are, Mr. Rath, there are 1, 2,
4 matters.
4 matters. You are appearing in all?
All matters.
All the matters.
Involving the identical order.
They are the accused.
Accused persons.
All of them are.
All of them are accused.
Okay.
13(1)(d), 420,
Against charge.
Against rejecting application for discharge. Lord, rejecting application for discharge.
Yes.
Lord,
Mr. Das, you are appearing? Yes.
CRPC 227 in the BS, the new act, it is 250, but the language remaining same. There is no sufficient ground to proceed against the petitioner.
Okay.
The accused will be discharged if the court comes to a conclusion that there is no sufficient ground to proceed against the petitioner.
Ground and materials.
Ground is material as the case.
Yes.
But fact remains that prima facie is not the consideration in 227, either into prima facie is not the consideration. Prima facie up to charge sheet.
Cognizance.
Yes. Discharge is no sufficient grounds to
These
proceed.
are the stages. These are the stages. The charge sheet is filed.
Correct.
Prima facie case, cognizance is taken.
Yes.
There is no ground to proceed.
Yes.
No material
Yes.
to substantiate this thing.
Correct.
Discharge.
Correct. Now here, after framing of after submission of charge sheet, before framing of charge, application was filed for discharge. What is the ground and what is the case? Quickly, I'll tell you, Lordship, what is the case about. Now, all these petitioners, 4 petitioners, they are staffs. Some of them are staff under the Commissioner of Excise. Some of them in the staff in the Sambalpur Excise Department staffs. And licensee is here. One is a licensee. Distillery is the licensee is having a distillery. Distillery for every excise, shop, like distillery, they have a minimum guaranteed quota. In case of distillery, the minimum guarantee, they will have to distill a minimum guaranteed quantity on the basis of which they have to pay tax to the government. MGQ. So there is a rules for the purpose. That is, for this, then prevalent rule is 97 rules. If a Lordship sees 97 rules first, what is the rule for fixation of MGQ? That is part of the record. That is at page 97 rules is available at page 35.
35.
Correct. Starts from page 35.
Yes.
Straightway, Lordship may kindly turn to rule 6C. So rule 6C. 6 capital C. Running page 38 of my brief.
You have a you have a hard copy?
That book is here. Book
No,
is wait a minute.
No, paper book. So I cannot.
Oh, hard copy जाऊने नहीं की.
No, the petition copy must be there, no?
Right, yes, it is.
I can underline it immediately.
ମୁଁ ଧରିଛି brief ଟା 858.
Cherry Moran. 858. No, 858 from that you give that revision, copy of revision. Page 30.
Page 38.
35, na?
30. It starts from page 35.
35. Yes.
Starts from page 35.
35.
Exact rules governing the field. Rule 6C. Minimum guaranteed quantity of bottling plant.
1 minute. 6 minimum guarantee quantity of
bottling
plant. Yes.
All the licensees of IMFL bottling plant shall guarantee for bottling 50% of the installed capacity of their bottling plants in a year as minimum guaranteed quantity. In case any shortfall in the minimum guaranteed quantity fixed for the plant by the excise commissioner. The licensee for bottling plant shall be liable to make payment of the duty for the shortfall quantity, and amount will be recovered as arrears dues from the license. So minimum 50% of the installed capacity is to be the minimum guaranteed quantity. Then who will fix it? In case shortfall in the minimum guaranteed quantity fixed by the excise commissioner. So excise commissioner has also a jurisdiction to fix the minimum guaranteed quantity. Two things, Miller. First is has to be 50% of the installed capacity, or in case the excise commissioner
power is vested
with the excise commissioner to fix the minimum guaranteed quantity. Now here I must bring to my lord's notice the license issue. There are
excise commission.
License issue. License record is the license is at page 34. 34.
30?
34. Page 34. It starts from page 33.
Yes.
The license is at page 34.
Yes.
Roman 8. That 2,500 cases of lower strength cheap foreign liquor is fixed per month as minimum guaranteed quantity, subject to approval of the excise commissioner.
2,500 cases.
Cases हेले हमको ताको LPL ले convert करी calculate करिया पे पड़ियो.
Fixed per month minimum guarantee quantity.
Subject to
approval of the excise commissioner.
So again, excise commissioner has the authority to determine this.
Yes.
Now 2,500 cases case हे गले कौन हुए case रो LPL टाको convert करिया पे हेले. Here in our case, which I have converted is 6.75 per case LPL. Then again calculating it 2,500, it comes to 16,200 LPL per month.
16,200
LPL per month.
200
per month.
MPL.
LPL per month. Then annual will be into 12. 1,92,000. 50%, whatever 50% of that will come as per license, subject to the commissioner fixing, should be the minimum guaranteed quantity. 50%.
But your emphasis is the
commissioner,
subject to
the commissioner.
Right.
Now, one more thing I must show to my lords. That is the DIC registration certificate. DIC has issued permanent registration certificate with an installation capacity of 15 lakh LPL per annum. 15 lakh LPL per annum. While giving me the registration certificate, DIC has given that fixation, which is obviously not in terms of Rule 6C nor the license. Now, there is an excise policy that also deal with fixation of MGQ. That excise policy is, along with my written note of submission, I have filed.
Yes.
Sir, my written note ta mo record rachi.
There.
It is there. Yes.
Which page?
Page 16. Go. '97-98 ବର୍ଷରେ
policy
page 16 of my written note of submission, para go.
Go.
97-98 ବର୍ଷରେ ଏହି ମଦ ବଟଲିଂ କରୁଥିବା ପ୍ରତ୍ୟେକ ପ୍ଲାଣ୍ଟ ପାଇଁ ତାଙ୍କର ବାର୍ଷିକ ଲାଇସେନ୍ସ ପ୍ରାପ୍ତ ବଟଲିଂ କ୍ଷମତାର 50% ବିଚାରକୁ ନେଇ ସର୍ବନିମ୍ନ ପ୍ରତ୍ୟାଭୂତି ପରିମାଣ MGQ ନିର୍ଦ୍ଧାରଣ କରାଯିବ ଓ ତାପରେ ପ୍ରଯୁଜ୍ୟ ଅବକାରୀ ଶୁଳ୍କ ଲାଗୁ କରାଯିବ. 50% of the installation capacity, not as per the DIC registration certificate.
That is then 15 lakhs.
That is DIC 15 lakhs.
15 lakhs.
This doesn't say the 50% of installed capacity as fixed by DIC. This doesn't say that.
Okay.
Installation capacity
is 15 lakhs as per the
that is DIC certificate.
DIC certificate.
But here the policy doesn't say that the installation capacity has to be taken into account as per the DIC certificate. Installation capacity can be assessed independent of the DIC certificate.
Read it then.
Right.
1997 ବର୍ଷରେ ଏହି ମଦ
ଲାଇସେନ୍ସ ପ୍ରାପ୍ତ ବଟଲିଂ କ୍ଷମତାର 25%. This doesn't refer to neither the rules nor the policy, refer to installation capacity as fixed by DIC.
Yes.
Over and above,
যদি সম্পৃক্ত bottling পরিমাণ মতো পূর্ববর্তী, then again you have to pay the tax on that. Okay.
then over and above, commissioner has the overall power to fix the MGQ. That is the plenary power of the commissioner.
Then what is the allegation?
Yeah, allegation here is, now in terms of this, for 97-98, commissioner found my capacity, installation capacity of my unit is 1 lakh LPL per year. Now the file accordingly was processed, fixing 50% of that, 50,000 LPL per year. Now there is one more catch. The total number of bottling units throughout the state, the government for 97-98 fixed 30,000 LPL for all the bottling plants. 30,000? 30 lakh, sorry. 30 lakh LPL for all the bottling plants. Documents are there in the police record itself.
Right.
That is the policy. Sei thare bhi lekha hai, jota apan pake padhuthili, sei thare lekha hai. Thik hai, dekho. 97-98 आर्थिक वर्ष ପାଇଁ ସର୍ବମୋଟ 30 ଲକ୍ଷ LPL ସ୍ଥିର କରାଯିବ. ତା ମାନେ this 30 lakhs is to be divided among all the bottling plants. Distribution has to be distributed among all the bottling plants, and accordingly MGQ is to be fixed. Now what the commissioner did, over and above 30 lakhs, he fixed 37.37 lakhs for all the bottling units, and accordingly proportionately 1 lakh LPL per year fell to my share. Commissioner approved it. Am I clear, my lord?
Right.
So commissioner approved this, which came to 50,000. Now I paid duty for 50,000.
Who is the licensee out of all these?
Manohar Jaiswal.
Huh?
Manohar Jaiswal, 861 of 2018. Criminal Division 861 of 2018.
Last case. The last revision appended to the first one. Last case.
Manohar Jaiswal, huh?
हाँ सर मु खाली से गोटे डॉक्यूमेंट देखो जी जो थरे कमिश्नर हैज फिक्स 37 lakhs over and above 30 lakhs page 49.
You just tell me who is Mr. Babaji Charan Kuntia?
Babaji Charan
Kuntia.
He is an employee in excise commissioner's office. These all of them are different. Someone is junior clerk, someone is section officer.
They are
the dealing with this file. Admitted
they are
position.
working
on
in
this
the commissioner's office.
Yes, yes. On
different capacity.
And on this file they are working.
Okay.
That's the admitted position. Now kindly turn to page 49. 49.
Yes.
As I have shown to your lordship, 30 lakh, as against 30 lakh LPL for all this bottling units, commissioner fixed, kindly see page 49, 37.27 lakhs, even beyond the quota fixed by the government. Kindly see, my lord.
49, where is it?
Page 49, my lord.
Yes, yes. Which part?
Sir, जो कहला Utkal distillery 18.9 LPL, so and so bottling plant 6.08, Poonam distillery 5.06. Let's you got it, man. Then high tech bottling plant 0.50 LPL, Castle bottling Latikota 0.56 LPL. This comes to 37. Over and above East Coast is 50, which will come.
This is handwritten.
We have calculated it. We have calculated it.
Okay.
We want to show that this fixation is even beyond the state's policy. State in the policy limited it to 30 lakh. Commissioner has fixed it to 87.27 lakhs for all the bottling plants.
All the bottling plants.
Yes. And so far as me is concerned, it is 0.50 LPL. 50,000 LPL.
You are high tech.
I am high tech. This Manohar Jaiswal.
Okay.
In terms of this fixation, we paid the duty. There is no dispute about that. What happened thereafter? Audit took place. Audit, taking into consideration to the DIC registration installation capacity, said that should have been 15 lakh per annum should have been the calculation. Accordingly, 7,50,000 per annum should have been fixed. Thereafter, the differential amount was fixed. 1,36 lakh some odd amount. They said that this is the loss caused to the state because there is a fixation contrary to the DIC registration set.
So what will you do if it is wrongly, rightly it is fixed?
Yes.
What is your role?
Absolutely no role in that. Based on AG audit objection, 2012 OLR says, based on AG objection or AG report, no criminal case can be there because that's not.
Consequence is if the MGQ is less or more.
Yes.
And you have to file, you will be subjected to financial implications.
What they
You have to
did
pay
is,
the money.
what they did is based on
that.
based on audit objection, they raised a demand against the licensee. Demand 1 crore 36 lakhs demand was raised.
Yes.
That you are liable to pay this amount, calculating that 15 lakh DIC.
Jaiswal, it was demanded.
Yes, demand was raised. That
Then
demand was challenged in this honorable court. Writ petition dismissed. Matter went to the honorable Supreme Court. I will just show your lordship the honorable Supreme Court's order.
Show me, where is that?
Honorable Supreme Court's order is at page 30.
30.
Page 31.
31. Yes.
This appeal has been filed against the judgment of the High Court, Odisha so-and-so, dated so-and-so, writ petition number so-and-so, whereunder the High Court has dismissed the notice dated 3/3/2006 issued by the Superintendent of Excise, Sambalpur, directing appellant to pay amount of 1 crore 36 lakh 69,672 towards excise duty on short production of so-and-so IFL liquor as assessed by the District Energy Center, Sambalpur. The appellant is a small scale unit registered of the DIC Sambalpur. It sought a license for manufacturing IFL in the year 1995. In its application seeking license, it mentioned the installed capacity as 15 lakh liters, and the shortfall was to be determined on the basis of the installed capacity, which I was saying to my lords. Now, the Superintendent of Excise Sambalpur, on the basis of an assessment made by DIC, issued demand notice for 1 crore 36 lakhs towards the excise duty on short-term MGQ high-tech bottling plant. Appellant challenged the said demand notice by filing writ petition in the High Court of Orissa, which was dismissed by the impugned order. Hard landed counsel for the parties perused the record. The short question in this case is that what was the installed capacity of the appellant's plant? Solicitor of the landed senior counsel appearing for the appellant, assisted by Sri Sam Diwan, landed senior advocate, submitted that as per Rule 6C as introduced in 25/11/97, the Odisha Excise Exclusive Foreign Liquor Rules 1989, the installed capacity has to be assessed by the Excise Commissioner, not by the DIC, as has been done in this case. Since the Excise Commissioner of Odisha in its letter dated 6th March 1998, written to the Collector Sambalpur, has assessed the installed capacity to be 1 lakh litre, 50% of which is 50,000 litres. Duty has to be paid on 50% of the shortfall, that is 50,000 litres, and admittedly duty has been paid on it. For contra, landed counsel for the respondents relied on the assessment made by the DIC, holding the installed capacity as 15 lakhs litre, if given by the appellant in the application for registration. Rule 6C of the writs as follows. Then Rule 6C, which I have read, is reproduced here. On bare perusal of Rule 6C, that after the said rules was introduced, all the licensee IFL have to guarantee for bottling of 50% of the installed capacity of their bottling plant in a year, as is minimum guaranteed quantity. In case of any shortfall in the MGQ fixed by the plant by the Excise Commissioner, fixed for the plant by the Excise Commissioner, the licensee has to pay duty on shortfall quantity. We have also gone through the letter written by the Excise Commissioner of Odisha to the Collector Sambalpur, annexed at PY4, annexed to this appeal, in which he has assessed the installed capacity as 1 lakh litres. In our opinion, the submission of the solicitor of the appears
1 lakh, huh?
Yes.
1 lakh litre.
Yes. In our opinion, the submission of Sri Solicitor of the appears to be correct and has to be accepted that duty has to be paid on the shortfall of the installed capacity assessed by the Excise Commissioner, not any other person or authority. The Excise Commissioner has assessed the installed capacity in the present case as 1 lakh litre, 50% of which comes to 50,000 litres. Admittedly, a duty has been paid on the same by the appellant. For the foregoing reasons, the appeal is accepted and the impugned judgment of the High Court is set aside. Impugned demand notice dated so-and-so, demanding appellant to pay 1 crore 36,59,672 is hereby quashed. We are told that pursuant to the interim order passed by the High Court, amount in question has been deposited. Since we have accepted the appeal, any amount deposited to the appellant pursuant to interim order passed by the High Court, otherwise shall be refunded to the appellant. And it has been refunded. Now, what they did, based on that audit report...
Let's come to charge sheet.
Yes. Kindly see the charge sheet.
Yes.
I'll just show your lordship, charge the from
now,
that.
Supreme Court has now decided that is 1 lakh.
1 lakh is correct.
Correct.
Fixation, there is nothing above that. 1 lakh is final.
Yes.
Now, what they are saying is, the files were moved from these junior assistant, senior assistant fixation of 50 lakhs. Thereby, they have abused their official position and fixation of 1 lakh by the commissioner is contrary to DIC restoration certificate as objected by the audit. That is how 13(1)(d) and 13(2).
Show me the charges. Let us see.
That is here. That's it.
The same amount, 1,36,000.
Yes.
What, yes, Mr. Das.
Then one just thing I'll point out, audit report
No,
part.
I don't think
As your
it's
lordship.
required.
As your-
Yes, Mr. Das. And the amount which you say that which is a loss to the exchequer, that amount Supreme Court says that you need to refund it. It is not loss, which they had deposited. How will you justify? In the face of page 31, just come to page 31. He has taken me to different pages. I need not go into all these things. The only allegation against him is by practicing whatever conspiring or whatever you are saying. It is a loss of 1 crore 36 lakhs 69,672 as cost to the exchequer. It went up to the Supreme Court. Supreme Court says that it is not loss, rather the money which is paid is to be refunded back. And what is the criminality left if a loss is the only ground? Why can't they be discharged?
My friend has finished it.
Yeah, he's finished.
Yeah, yes, finished.
Now, this is the only one point you answer it.
I've got three submissions. I placed only a few portion of that input orders. One. Second submission would be my endeavor will to place the instruction and receipt with regard to the complexity of the 4 petitioners, not 2. And I will also place a judgment of this Hon'Ble Court in this case. These are 3 parts of my submission.
All these things must be prior to Supreme Court judgment.
No, in all those cases, Supreme Court judgment preparation to service and findings came out. I will bring to Lord's notice. And the Lord's, my first submission would be Lord's the input orders.
Please.
I will not place the entire thing. I'll just place the
relevant part.
Lordship, coming to page 21 of Lordship.
20?
21.
Yes.
I hope your Lordship is holding that Babaji Charana Kuntia case.
Yes.
Page 28.
20?
21,
yes.
The Lordship can that page 20, it starts from 20 minutes. Page 20.
20, okay. Peruse the.
Peruse the case record as well as the documents filed by the learned counsel represented the accused and case cited a citation filed by them. I am agreed with the submission as laid by the learned counsel for the prosecution concerning to the manipulation of statement in relation to high-tech bottling plant while forwarding to the governments for fixation of MJQ. The Honorable Apex Court has declared extent of power of excise commission exclusive to fixed quantum of referring to Rule 6C of the Odisha Excise Exclusive Privilege Foreign Liquor Rules 1989, as well as about installed capacity of the plant of the accused Manohar Jaiswal on the basis of letter written by the Excise Commission Odisha to the collector, Sambalpur. Such views of the Honorable Apex Court has been accepted by the prosecution counsel, but the allegations brought by the prosecution appears altogether different. The government had directed the Excise Commission to submit statement fixing quantum of MJQ as per the production capacity of the individual unit granted in PRC. PRC abbreviation is Permanent Registration Certificate issued by DIC and to supply the copy of the PRCs to the said units. The commissioner complied with the order of the government in part by submitting the statements of the production capacity and the MGQ of the unit, but without attaching their PRCs. The PRC of Messrs. High-Tech bottling plant granted for 15 lakhs liters, but the statement is made to 1 lakh liters. Thus, there is flagrant misuse of official position by the commissioner, and his policy, seat staff who prepared wrong statements, falsifying the requisite facts against Messrs. High-Tech bottling plant. The government, according to the statement of excise.
First point is the bottling plant granted 15 lakhs a liter,
Right.
but the statement is made as 1 lakh. That is manipulation.
The government, according to the statements of the Excise Commission, notify MJQ of the unit, which is obviously wrong, being not followed by the actual figure as given in PRC by DIC. It appears Honorable Apex Court has only been apprised of the letter issued by the government to the collector Sambalpur and nothing. The real commission of illegality remains at the hand of the excised commissioner and his policy seat staffs, who prepared and sent statement to the government, a wrong one, suppressing the true installed capacity of the unit in question. Further, the Honorable High Court in CRMC as Supra has dismissed the petition of the accused Nrsinga Panda seeking quashing the proceeding, being convinced with the submission of the Council of the Vigilance that order passed by the Honorable Apex Court in Civil Appeal number 2644 of 2009 relates to civil consequences of the act, and it will not absolve the accused person of criminal liability they have incurred. Therefore, in the light of the discussion, as aforementioned, and the views taken by the Honorable High Court in CRMC 2533 of 2015, the citations of the Apex Court as reliance placed by the Learned Defense Council squarely not applicable to adjudicate adjust the threshold in these proceedings
But see,
to the whole that the
Mr. Da-
accused might.
it says that these are the civil consequences. The Supreme Court judges civil
No,
consequences.
Your Lordship, I am-
Binding of a civil court is obviously binding.
My Lord, sir, may I-
If you admit the issue in list is the same, that is a civil consequence, it is a criminal consequence. But there is a finding of the Apex Court. It was rightly done, and that
being emboldened by this the Honorable Supreme Court judgments.
that is 2533. Show me.
I'm placing
Where is
that
that?
judgments.
2533.
The judgment, my lords, relied upon by the petitioner in this case was placed before the Law and Trial Courts while disposing their discharge application. And this is a case, my lord, where this particular Supreme Court judgment was placed for quashment of the entire proceeding. And the proceeding pertaining to TR number 81, should I place it, my lords? 1611-2000, the Learned Council. 1611 is not.
2015.
I think it's 15.
2015.
Learned Counsel for the petitioner and a Learned Additional Standing Counsel for the Vigilance Department. This is an application under section 482 of the CRPC. The petitioners filed this application to quash further proceeding in TR case number 81 of 2009. The input order was passed in this revisions, my lord, pertain to TR case number 81 2009. They initially took the stays for quashing the entire proceeding modes. This is that the order.
Who was the petitioner here?
And that the Mr. Jaiswal, my lords.
No, Nrsinga Panda.
And Nrsinga Panda, his role I will place, my lord. He is the complete sheet I will place, my lord. He is this one of the staff of the excise department. Let me place it, my lords. This is an application, TR number so and so, the cutter arising out the cutter vigilance pay scanner so and so, para 3. The petitioner was working as a junior assistant policy seat in the office of the Commissioner of Excise at Board of Revenue Building, Cutter. He was attached to his superiors, namely Dinabandhu Patnaik. He is also accused in this case, who was working as senior assistant in the policy seat in the aforesaid establishment. It was the duty of the petitioner to deal with the different policy related matters relating to the excise policy published every financial year by the Excise Department as per the mandate of Article 47 of the Constitution of India. The state government being the privilege holders of the trade of liquor, it is the assigned responsibility of the state government to ensure supply of hygienic and safe portable liquor to the consumers and to curb the inflow of spurious and illegal beverage in the state. Accordingly, the state government published the excise policy for the year 1997-98, wherein for the first time a provision was made to fix of minimum guaranteed quantity MJQ for manufacturing the foreign liquor by the manufacturer. It was decided that 50% of the installed capacity of the concerned plant should be the parameters to fix up minimum guaranteed quantity MJQ. Accordingly, amendments were made to the rules. One, Messrs. High-Tech Bottling Plants Private Ltd. of Sambalpur applied for fixation of MJQ of their plant. On being asked, the said enterprise furnished permanent registration certificate for computation of MJQ, and accordingly, on the basis of the available documents, the MJQ of the plant was fixed. The allegations against the present petitioner is that the total production capacity of the said plant was 150,000 liters per annum. However, he prepared the document showing that the minimum strength of the aforesaid enterprise is maximum strength of the aforesaid enterprise is 1 lakh liters. And accordingly, the MJQ was settled for him. There is a stipulation in the relevant rules that in the event the bottling plants do not achieve 50% of the target, then a penalty will be imposed upon them. Accordingly, as there was a loss to the government exchequer, upon completion of investigation, charge sheet has been made against the present petitioner and other excise officials.
So then the
management.
Then the allegation is, instead of 150,000 liters, they've given a report that is 1 lakh. On that basis, MJQ was fixed. That's the allegation. Okay.
My lords, for commission of the offense under section 13(2), reduce section 13(1)(d) of the Prevention of Corruption Act, reduce section 120(b), 140 of the IPC. In courts of hearing, London Counsel for the petitioner very emphatically states that the demand notice issued by the Superintendent of Excise for realization of rupees 1 crores 36 lakhs 69,672 has been quashed by the Honorable Supreme Court in the special leave to appeal civil number so and so, on the ground that there has been violation of Rule 6C of the Odisha Excise Privilege Foreign Liquors Rules 1989. In as much as the Commissioner of Excise has not fixed installed capacity of the bottling plant in question. Rather, the same has been fixed by the DIC, and accordingly, the notice was issued was quashed. As far as civil appeal is concerned, it was relating to the demand notice issued to the
by the Superintendent of
issued by the Superintendent of Excise on the basis of assessment made by the DIC. While preparing the installed capacity of the petitioner and to fix the MJQ, the department has taken note of the fact that DIC Sambalpur has granted license for manufacturing IMFL 995 and total capacity of the plant is 150,000 liters. London Additional Standing Counsel in his argument before this court submitted that the order passed by the Honorable Supreme Court in Civil Appeal number 2644 of 2009 relates to civil consequences of the act, and it will not absolve the accused person of the criminal liability they have incurred. I find sufficient force in the contentions raised by the London Additional Standing Counsel for the Vigilance Department, and hence this court is opinion that the criminal miscase filed for quashing the entire proceeding is devoid, entire proceeding on the basis of this judgment of Supreme Courts is devoid of merit, and the same should be dismissed. Accordingly, criminal miscase is dismissed. Honorable Justice Mishra. My lords, this is the second thing, my lords. I crave your lordship permission to place the instruction I received And my lords, with regard to individual complicities, my lords, apart from that fixation and all this, what is the where the culpability emanates, my lords?
What is this?
My lord, this is the instruction which I will place it on. I start from paragraph 1, my lords.
You served on me. No?
Correct, you are correct, but I will give that to Madam.
No, you are placing it, you are relying upon without serving me a copy.
That's true, that's true.
Give a copy.
Because that might not be part of the charge sheet.
No, this is
So he has to base on the basis of charge sheet.
Yes, my lord. I will not place one line. Let my lord senior verify if we have say anything, any word again beyond the charge sheet. My lord. This is the instruction received on the basis of charge sheet. The first line says, it is stated that in the charge sheet that the state government, paragraph 1, my lords, it is stated that in the charge sheet that the state government published excise policy for the year 1997-90 to fix the minimum guaranteed quantity, in short, MGQ for manufacturing foreign liquor by the manufacturer in their unit against their respective production capacity. It was decided therein that 50% the installed capacity of the plant should be the minimum guaranteed quantity. Said policy was introduced on 23/11/97 under Rule 6(6) in the Odisha Excise Privilege Liquor 989. Such policy professes that in case of any shortfall in the MJQ fixed for the plant by the excise commissioner, the license of the bottling plant shall be liable to make payment of the duty for the shortfalls and will be recovered as area dues from the licensee. Accordingly, the Government of Odisha Revenue and Excise Department notification dated 25/11/97 addressed to Excise Commissioner, White Memo number so-and-so dated 25/11/97 to all collectors, Superintendent of Excise, asking to collect the permanent registration certificate, in short the PRC, of all bottling plants. The Excise Commission Office by letter dated 18/97 in reference to government notification dated 25/11/97, issued letters to the bottling plants to furnish a copy of their PRC issued by the Industry Department DIC in favor of the bottling plants for fixation of MJQ. Pursuant to it, all the plants in Odisha sent their respective PRC. The charge sheet further reveals that on receipt of the permanent registration certificate from the bottling plant, accused Nursinga Charana Ponda, he is involved in this criminal division number 860 of 2018, which is Lordship Board Lords. Junior Assistant Policy Seat of the Commissioner of Excise gave a note in the MJQ fixation of the bottling plants, white file number so-and-so, on 9/2/98, mentioning that according to the government notification, the bottling units were asked to furnish the PRC report issued by the DIC for ascertaining the installed capacity and simultaneously prepared a statement showing production capacity and the MGQ of all bottling plants for the year 97-98. The note and statement of junior assistant were countersigned by accused Dinabandhu Patnaik. He is involved in criminal division 859 of 2018. Senior assistant of the policy seat, and then accused Babaji Charana Khuntia, the present petition, the file your lordship holding. He is a section officer policy seat, submitted the note to accused Karthik Chandra Das. He was the commissioner of excise in the case against whom abated due to his death, who approved the note.
What is the production capacity written in the note?
No, I'm coming back. I'm coming.
You just tell me, for that is the whole gamut of the case. What is the production capacity?
I'll not place much, Lords. I'll just place this.
You just answer me, what is the production capacity shown in the note placed before the commissioner through all these accused persons? This is going here and there. What is the production capacity shown by a note is prepared? It has gone through many people, section officer, blah, 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 and went up to the commissioner. Commissioner, on the basis of that note, approved the MJQ. Okay. MJQ is in fact, what was the MJQ? What was the capacity? Capacity is 1,50,000 bottles. And what was shown?
1 lakh. I'll just fill up.
It is not written, I have seen it.
Lords, individual completion, just placing it. I will not take much time. The note state para 4, the note and the statements of junior assistant.
Show me that note. Show me that note. That if that is the basis of your entire case, your entire case hinges upon that particular note, on the basis of which the criminal case is being registered. Show me that note. Finish. Show me that note. And why to go into all this thing? You are making that note is a basis. Note was placed by Nursingo and approved by the other people, gone through different tables and reach up to the commissioner.
Right.
Commissioner approves it. That's the whole case.
Right.
Show me that note
I'll-
instead of this instruction.
I'll place notes. Lord,
Get it tomorrow.
Lord, this note is here,
Show me. Just
part
see.
of that charge sheet. Lord, I'll just explain one thing. Lord, I have
Show me
placed-
that note. Let
Yes,
me
yes.
understand.
It is the note.
If
Kindly see.
there is a finding, there is a finding. What to do?
Kindly see, Lord, where in the rules or policy, anywhere, DIC is the given basis for fixation of MGQ. Not at all. No rules.
This is the note.
This is the note. No rules, no policy says that DIC will fix the MGQ. It changes the whole excise law. DIC is never authorized.
Mr. Ratho, I must tell you one thing.
Yes.
If you overlapping complicated facts, then it
Yes.
has to be sorted out in the trial.
No, I do not complicate any fact. That,
No,
as your lordship
put
rightly
it very
said.
straight.
No, not at all. Let me
If you bring so many facts into it,
No,
then
no,
it
no.
has to be sorted out.
No, I am not raising
I'm
any
not
fact.
going to
No,
conduct
your
a
lordship
trial.
make a clear look. No, I am not raising any fact. Not at all.
I just want to go to the root of it.
Yeah, Lord, yeah,
If
that
the
is-
root goes, everything goes.
That is there. That is there, I have shown.
The long and short of the matter is a note was prepared by one Nursingo Panda, whatever, saying that this is the capacity, bottling capacity of this high-tech distillery, whatever. On that basis, MGQ was fixed. And it was found shortfall, therefore a demand was raised. Demand was subjected to question in the Supreme Court. Supreme Court said that no, it was rightly done and the demand was wrong and there is no loss, you refund the money. And everything is germinating from that particular note.
In fact, the note aspect, different facets, my lord. That's why I was.
No, you
praying-
can decorate it by saying whatever, but the criminality starts from that particular note.
Exactly, my lord. I
If that note, if the note, it's all right. Let us see. Utkal distillery, high-tech, where is high-tech? Yes, high-tech. Yeah, high-tech, 1 lakh. This is what they have shown it is 1 lakh liter. This. So this is, and your whole case is here. Why they have shown it 1 lakh
My lord, sir, if your
instead of 1.5? That's the whole case.
That is one of the response. If lordship permits, my lord, just I will just complete two pages, my lords. I will not waste your lordship time. My lord, may so per note aspect, my lord, I initially submitted for lordship that the culpability emanates from this particular note, my lord. That is paragraph 3, my lords.
That is the only culpability according to you.
No.
Instead of 1.5, they have shown it 1 lakh.
My lord, it has other, how they work in tandem, my lord. And that's placed, my lord. Paragraph 4. Paragraph 3 is about the Nursingh's Charter's note, my lord. Now, paragraph 4 pertains to Dinobandhu's, my lords, and Babaji. Let me place it, my lord. Only for my satisfaction, lordship may kindly bear with me, lords. Paragraph 4. The note and statement of junior assistants were countersigned by the accused Dinobandhu Patnaik.
Come by para 5, I read the.
That's
the RC reveals.
And so the charge sheet further reveals that the accused Mano Jaisal, owner of high-tech bottling plant, had secured PRC from DIC, Samalpur on 25/11/95, fixing the installed capacity of his unit per annum is 15 lakhs liters. It is alleged that besides the methods high-tech bottling plants, the production capacity of the MJQ in connivance with each other, showed undue official favor to accused Manor Jaiswal by suppressing the actual figure and instead sent wrong figures of production capacity.
Why are you reading the same thing? Instead of 1.5 lakh, they have written 1 lakh. That's the whole thing.
Well, I'll compare with the 7 only. Para 7. I will not drag it further. Production of MJQ in respect so and so, para 7. It is alleged that the fixation of MJQ, the Commissioner Excise is assisted by one Deputy Commissioner Excise who
Instead
is
of sending to Deputy Commissioner, they will send it to Commissioner.
The file was directly sent to the Commissioner after being processed by the Assistant of the Policy. This shows in a clandestine manners, they work in tandem to has the conspiracy.
Commissioner is an accused?
Yes.
He is an accused. Who is accused number? Commissioner?
He is died. He is dead. He died. Abated. He died. And while the concerned file, instead of routing through the Deputy Commissioner, the file was directly sent to the Commissioner after being processed by the Assistant of the Policy Section, which clearly proves the malafide of the Excise Commissioner and his subordinate staff in the Policy Sections. And Lords, if Lordship permits,
I got it now. Yes, Mr. Ratha, you just tell me.
Yes.
How they have arrived at the figure 1 lakh.
Yes. That is based
How
on.
will you justify
yes,
that?
that is based on the production, actual production. That is also the police record. That is also the police record. Actual production kindly see that. That's their own report, police report. Kindly see.
You have to justify that 1 lakh.
That is there. I don't need. They have given. Kindly see my production per annum. LPL 1,09,000.
Reference to the subject.
Actual production, year-wise given by the police.
The capacity of the bottling plant has not been fixed.
What's the wrong? No?
License issue. Production.
LPL, kindly see LPL, man. But she got 1,09,000. So that is their report.
This is not part of the charge sheet.
Yes, part of charge sheet.
Data.
Yes, which I have given the part of charge sheet only.
1 lakh? Where is that? 1 lakh?
1,09,000 LPL. DL, LPL, dita heading rachi. DL ta chhad diyantu, LPL ta dekhantu. Last column ta.
1 lakh boli kood lekha hai.
1,09,000.
97, 98.
Sir, mujhe highlight kar dijiye.
97, 98.
So that is the relevant year. That is the relevant year.
Then if it was 1,09,165 points.
So they have taken 1 lakh. They have taken 1 lakh. And that too, Lordship will find. So Honorable Supreme Court has said it is not the DIC to fix the MGQ, it is the Commissioner. Kindly see that order. It can't be said like this. Kindly see the order. Honorable Supreme Court says it is not the DIC. How can you say like this? Kindly see page 32, my lord. Again. Kindly see page 32. In our opinion, submission of Sri Sorabji appears to be correct and has to be accepted that duty has to be paid on the shortfall of installed capacity assessed by the Excise Commissioner, not by any other person or authority. Then how do you rely on DIC?
Duty has to be fixed on the basis of installed capacity or production capacity.
But installed capacity.
They have gone by production.
Installed capacity, production capacity, the annual production is taken, then they have fixed the
installed capacity is 1.5.
1.5. Yes.
Your production capacity is 109.
109.
And they fix
the MGQ as 1 lakh.
Put a note saying that is 1
lakh.
1 lakh. 1 lakh. This is the whole
payment. What is the pecuniary gain? Nothing.
No.
And insofar as the loss is concerned, Supreme Court said that there is
no loss.
Lordship may turn to my learned friend is good enough to incorporate the rules, my lords. My lords, the page 6 of that, my learned friends.
Which rule? 6.
Rule 6. I read it, my lords.
Yes. Where it is DIC.
Minimum guarantee quantity of bottling plants. All the license of so and so beer, bottling plant.
Install capacity of the bottling plants.
50% of the insult
capacity, not by the DIC.
What I want to impress a lot of install capacity and the MJQ lots, fixation of MJQ lots are complementary with each other, not competitive. What I want to impress your lordship notes, the install capacity when a particular distillery was installed. At that time,
why can't we make it so simple?
So dependent that particular
50% of install capacity.
Yes, my lord. Install capacity at the initial
issue is,
stage are issued by the industry department.
Supreme Court says that install capacity 50% has been done, and so therefore
The Supreme Court's orders pertaining to quashment a particular demand notice, my lords. No, this cannot be a patient service. This was also, this Supreme Court judgment was also placed before this Honorable Court for quashment the entire.
If in the charge sheet, if you say this is the amount the exchequer has
loss.
Yes.
Loss.
Use.
And the Supreme Court says that there is
no loss.
What will be the consequence?
No.
And the High Court order which you have read it out, High Court doesn't say anything, doesn't deal with anything.
Right.
At the end, he says that I don't agree.
No.
Without reasoning.
No, he has given the reason.
Doesn't deal with the product
reasoning.
install capacity.
Narration of facts, last paragraph you read.
That's right. That is what I was trying to tell you.
The Lord and Council petition of the empirical states that the demand.
And last paragraph is all narration of facts. Last paragraph. Read it. 9, para 9.
Para 9. No, that is a submission of the State Council.
Then in that paragraph only last 2 lines. I find sufficient force.
In the contentions.
That's all.
Well, in fact,
the reasoning is not given.
The observation starts from paragraph 6, notes. In courts of hearing, the London Council petitioner very emphatically states the demand notice issued by the Superintendent Excise for realization of rupees.
Sir, what you are trying to tell is these are civil consequences. It has nothing to do with criminal. And the High Court is also going by your submission.
This Honorable Court,
I find that the contention raised by the council.
After perusing the order passed by the Supreme Courts with regard to the same plants plots, this Honorable Court was not inclined to quash the entire proceeding.
Only thing what Mr.
Yes.
The completion
you have
of
to
the
explain
staffs.
is if the
in suppressing and giving
capacity is production capacity is 1,09,165.600.
That is the actual production.
Actual production. Who has given you authority to make it 1 lakh?
They are done surreptitiously.
It is not, we have not made it 1 lakh. Let me tell
Then
you.
who has made it?
But they take an assessment based on the actual capacity. Sometime also the production goes off. May not kindly consider this.
So that is why the
culpability starts.
That is why rule 6 is very good, very well worded. It says the install capacity has to be.
Install capacity is no
1.5.
Not 1.5. Install capacity is not 1.5, my lord. It's not 1.5.
Yes,
install capacity. Sir,
carry on.
Install capacity has to be assessed by the commissioner. Whatever amount comes out, he will fix it. Now let's make kindly see.
If there is a conflict.
That 1.5 theory, it is based on my application to the district industry center to get my DIC registration.
That is 15 lakhs in your.
तार किसी justification एठी नहीं है. सेटा for the purpose of registration, we give a imaginary figure.
That is install.
That okay, please. Sir, kindly see rule 6. Rule 6 is the procedure for fixation of MGQ. Policy is the fixed procedure for fixation of MGQ. Nowhere it mandates that DIC registration will be the basis. Nowhere. But they have formulated the case based on DIC registration. How can they do this contrary to rules again? Kindly consider
that you can't complain because on that basis you got the benefit in the Supreme Court. On the
So,
basis of otherwise install capacity if you take it is 15 lakhs.
Sir, kindly see that cannot be taken. That is why Honorable Supreme Court rejected that.
No.
Specifically,
So Honorable Supreme Court has accepted the fact that it is only 1.5 lakh.
1 lakh. Sir, Honorable Supreme Court has accepted 1 lakh.
Where is so
Sir, kindly.
And the power of the commission.
Sir, kindly see. It is wrongly placed. Kindly see one. Sir, kindly dekho. Sir, see.
Oh, this is written.
Yes.
Yes, this is written. We have also gone through the letter written by Excise Commissioner Orissa, the collector.
Yes.
Sambalpur.
Yes.
Annexure 4. Annexed to this appeal, in which he has assessed the install capacity
as 1 lakh. What more can be said?
On the basis of this noting, my lords.
What noting?
That's noting of that.
Then it is
We
fine.
authorize them to say that install capacity means at the time when the installation
He is
was
questioning
installed.
Supreme Court then.
My lord, my point is
He's
that
questioning
the
Supreme Court.
four staffs of the department, including that the deceased commissioner, my lord, they work in tandem, my lords, to has the conspiracy to give benefits to the Mr. Jaiswal, my lords, to get huge benefit. It's not 1 lakh or 2 lakhs, some crores of rupees, my lords. And for that reason, my lords, they moved the particular application to the Honorable Supreme Court, quashment of that demand notice. There, Supreme Court said that no, Commissioner, we don't disagree that Commissioner has the power to fix MJQ. But on the basis of what? On the basis of install capacity. What is that install capacity? Now, when the distillery started functioning, it's installed. There the Commissioner.
According to you, what is the install capacity?
It's 1,50,000. That was separate. That was impact. That's the reason, my lord, I was placing, my lords.
Why they say like this?
Supreme Court has now accepted it is 1 lakh. What?
Yes.
My lord,
Right, whatever.
I respect that. I don't disagree, my lord. I have no audacity to disagree, my lord. What I want to say, these 4 staffs of the commissioner, they are direct. They have, my lord, the materials on records, my lord, on the charge sheet, my lord, clearly disclose grave suspicion with regard to the complicity in giving this note only to ensure giving benefits.
Can the trial court arrive at a finding to say that no, the install capacity is 1.5 lakh? And these people have done it for 1 lakh.
Will not.
So therefore, they should be.
No. We'll not delve into that, my lords. Why entire thing that who authorized you to, and my lord, what is this, my submission, my lords, that while approving the MJQ recommended by the excise commissioner, the government asks the excise commissioner to submit permanent registration certificate issued by DIC in support of the actual installed capacity of all the distilleries and bottling plant the state verification. But deceased accused, the commissioner.
Do you have this annexure 4, which was filed before Supreme Court in the appeal paper book?
Sir, देखो से जो DIC टा दे दी जल्दी ये खाली unnecessary देखो the certificate called it will not call for any right देखो sir से certificate रा
annexure 4
sir से DIC से हाँ certificate रा that is there sir देखो ये ना उड़ा खाली अଯଥା टा केस कर लोग को हैरान करिया कथा
एटे पूरा
लोग मरी जीवे आगे एमती कहि करी
पूरा चंचक होता है क्या नो डाउट
एमती कहि कोन सर देखले certificate
पठेबे निजे से लेके लॉकेट नगल 1
ना तामन तो जहां फिक्स हैला सब भूल गेला जे जे उठे फिक्स करले तां कहीं
you answer one thing, whether the finding recorded by the Supreme Court is binding on you or not.
I agree. I respect the Honorable Supreme Court.
Unless this finding is reverse, otherwise he cannot be convicted.
I agree with the findings of the Lord Supreme Court.
Why should they face the trial?
My point is that they have done something in a clandestine manners, bereft of what I suggest, what I submit, my lords. My lord, they have 1 minute. My lords, they have done it, my lord, in violation of the direction of the law prescribed made on for which, my lord, in violation of the direction of the law prescribing the mode in which they should have right, my lords. The mode is that, my lord, they should give the note that this particular installation has the PRC, this thing. They are aware of this thing. But in lieu of attaching that permanent residence certificate with like this, they are giving their own notes.
The ideal thing would
and
be
on the basis
Supreme
of
Court
that,
should have taken observation.
Forget about money, my lord. 1 lakh is solid. But what thing they have done? These 3 people.
Findings recorded by the court.
Well, with regard to, my lord, the quantum, with regard to the complicity, criminal liability.
No, this finding, that is, see, it says that the assessed the install capacity as 1 lakh liter.
Assessed by the commissioner, and commissioner has the power to do it. But commissioner, my lord, is to do on the basis of the material, that is the material placed by the excise department.
That is what these people have done.
And they have done it, my lord.
These people have also done 1 lakh.
Well, they have done it, but that subsequently that is not, that cannot be considered ratification. That cannot be considered as a one kind of approval. No.
Show me.
So the commissioner.
Show me annexure 4. That's all. Let us end it here. Annexure 4, which was relied upon by the Supreme Court. Annexure 4. In the page 32, this Annexure 4 is being referred to by the Supreme Court.
Page 32 minutes.
Yes. Annexure P by 4.
Bare perusal.
Where perusal of Rule 6C.
Last two lines. We have
also
gone through
letter
the
written by the Excise Commissioner of Odisha to the collector, Sambalpur, P4, annexed to the appeal, in which he has assessed the install capacity of 1 lakh. I'll just produce that one.
That is here, we have annexed it. That is the fixation by the commissioner. We have annexed it.
On the basis of that floating only.
Oh, that's what I wanted to know.
We have annexed it.
And he died in the meantime.
Yes, so
It na? No, no, it happens. We have annexed it. That is at page 40. No, I don't know. It a government. The commissioner letter to the collector. That I'll produce it. Let's say reserve it, we'll produce it.
you produce.
We'll produce it.
You produce it.
I'll produce it.
Well, and this document which you have shown this
So
one,
that may be record.
and all these things. No, you give it. I can't read so much.
Yes,
See,
sir.
the moment
The
you ask me to read so much, I will be under the impression that you should
No, I'll take
sort
it back.
out
I'll
there.
give the relevant person. So
Sort it out there.
that letter also I'll file.
And you also take it and place it on our file, huh?
I'm sorry not for providing my learned senior with the copy, my lords.
So that's what exchange.
I'm sorry, my lords. But he is fair enough to give all
Third
the
in part,
copies, my lords.
third in part, leave the matter next week. Only I'll take only 5 minutes. Show me that. I'm clear.
I'll produce that.
Your lordship fix it too, my lords.
Thank you.
I didn't know. Say,
He will get the that annexure.
I'll give that.
I'll only see that annexure. I understood it now.
Can it be 22nd thou?
So let it be 18 then.
18th will be Mr. Rijvi's day. 15th and 18th.
It will be 16.
Letter
ta kadi de di.
Annexure kadi de. Near.
22nd thou, just 5 minutes maybe after lunch.
See, I should not forget. I put in 1 hour. I generally take 10 minutes to finish it up. 1 hour I wanted to know because it's a charge thing. Even if you put them to trial, you won't get anything.
Hey, তিনটা জায়গায় excise commissioner
Sir, এইটা, এইটা।
চঞ্চল কথা করছেন। At least I am convinced.
এটা আগে স্যার।
The only thing is, in place of 1,09,000, they made it 1 lakh, and which has been endorsed by everywhere.
টানি কি পকেলা পড়ে
including the Supreme Court.
And in put it in nicely.
And in the Supreme Court, you should have said that the criminal prosecution which you have initiated, the observation should not.
File kar debe.
Because these are civil proceedings. The findings are binding on the criminal court.
Findings
To convict them unless you say
findings are
capacity is 1.5.
The findings are all right. Suppose lordship say that finding is 1 lakh. And the same noting is there with the
1 lakh they are exonerated.
No, exonerate. They have done it in an illegal in a clandestine manner.
Let it be
but
whatever.
can it
But
be
it is accepted by a judicial determination. By a judicial determination, once it is accepted.
A criminal act done in a clandestine manner cannot be ratified by a judgment of the Honorable Supreme Court. If fixing a particular date regarding the quashment of a particular demand notice.
What else, sir?
So for finance aspect, we return back. But those
And
people,
he says that no loss to the exchequer.
to put it in Odia,
That's the finding.
they should not go scot. He was
The business was such. They'll have to do that.
He's murmuring that Supreme Court was in dark. So for this aspect is concerned, the individual complicities.
Dark. Then you can't.
So anyway, we'll see. Get that for. Okay, 19. And if you have anything, see your written instruction is revealing nothing. If you have anything, they just narrate the facts. That will lead you nowhere.
2 p.m. Send 2 p.m.
Yes. What is correction? हाँ हाँ कर देते ठीक है 19 लिख दो seeks permission to correct the cost title permission granted he may correct the change in the report of the ठीक है yes चलो वीकली देख लेते हैं वीकली में कुछ है क्या
Actually, yesterday, my lord, my learned sister, my
yes
lord,
yes yes हाँ yes argue
59.
you read it are you ready
Your Lordship, I have.
still you want time but you have to argue to your satisfaction forget about that
To fine tune the arguments.
are you ready or tomorrow you tell me what
Your Lordship, I'll place before Your Lordships today.
Today?
Yes, Your
Very good.
Lordships.
Oh,
Because the note
yes.
and all, then I'll be.
Are you sure?
Prepare written note
You should.
Your Lordship, I have prepared a rough written note. I have prepared it for myself, but
where is that give me
Your Lordship, I have prepared it
no
for myself.
this is an opportunity for you to argue prepare a note and everything
Tomorrow.
Yes.
sir.
so
Yeah,
that
that
it
will
will
put
be
me to
you know this is an opportunity for you
Yes, Your
so
Lordship.
do it tomorrow
Your
Huh.
Lordship.
come with the written note give me
That's okay.
Mhm. 81 all these matters if we have already tested
84, can you take a supplement tomorrow? It will dispose of.
80?
It's not revised.
81 and 82. We will pass it.
84,
84 रे कौन खिला
order passed by the special court is not revisable. It will be on the basis
तो
of.
supplementary नहीं आता ना तभी
What is your matter?
हाँ supplementary will not revisable then why
78 also.
hmm
78 was also.
78 78 को
78 आपका है ना?
fast over
78 टा मतलब कल को
78 you are not there na
Yes,
so therefore
yesterday
it
I-
will pass over
Actually.
only this way.
Yes.
How it does?
84 tomorrow.
Yes.
Supplementary.
Hmm. Anybody who is ready?
35, my lord.
Huh?
35 was passed over.
35 supplementary.
No, no, weekly.
Java.
35.
35. Yes.
35 criminal division 1617 of 2000.
It is state.
State courts.
How किसी दम नहीं कि कल tomorrow.
Eh?
Tomorrow.
Who is appearing?
I the state case. My
State
lord.
case. Discharge have been allowed by the London Special Judge Vigilance. Against the discharge order passed by the Special Judge, the Vigilance has filed a revision.
ठीक ଅଛି ମୁଁ କର
ଆପଣ କରି କାଲି
କାଲି କରିବ ନା ଏ ଯେ ଯୁଥିବ
2008 they were discharged.
My senior is my well-wisher.
Hmm?
Well-wisher.
Hmm.
When I was bachelor, he comes to our chamber. Tell me always, go and take roti and tadka. When I go to him, first cold drink, then tea, then biscuits. He's senior, my
Don't
senior.
expect those things now. Because he
No,
is
no,
doing
because
it.
he's a government advocate.
Let us see what was your age that then. Where is the charge sheet? Charge sheet you have. You have charge sheet.
39? No, 35.
35. You tell me the age of this.
It's more than 70.
What happened to the other accused?
My lord, other accused, he was not arrested, so against him, the case was split up. The London Special was also stated so.
Split up.
No,
And charge is framed again.
no charge. Since the case stands split up against the main accused, namely E.B. Prasad, page 8 of the order, para 12, my lord.
What happened to that case?
No, he has not yet been arrested. He is the main accused.
Absconding.
Absconding.
What is your age? You are not written.
Man, age is in Bhaklaznama in the 2006 55. CRLMC 1360 2006 Bhaklaznama was filed. 55. Now
55 that time.
73. I was telling him more than 70.
He's alive.
He's alive. Last week he has come to my chamber for discussion.
75.
75. And he's not suffering from different ailments. He's coming with his son. ତା ନାଁ ହେଲା ଗିରିଜା ନନ୍ଦନ ମହାନ୍ତି।
ଦେଖନ୍ତୁ
ଏଜ୍ ଅଛି 52 ଡେଟ୍ ଅଫ ବର୍ଥ ଇଜ 2452
କେବେ 52 which year?
January April 24/1952
ଗିରିଜା ନନ୍ଦନ ମହାନ୍ତି ତ
No, year you tell me, year of filing charge sheet. You are reading charge sheet, na?
Yes.
The date of birth is speaking
245.
26/5/2003
2003 he was 52.
No, date of birth in the charge sheet means date, year of birth 24/9/52. 52 means
71 years.
71.
71 years. You are discharged. Now you frame charge. And he will be convicted or acquitted after posthumously.
Tomorrow after it.
Posthumously. Yes.
Tomorrow in the supplementary list.
Supplementary.
Waiting. The orders are passed. These matters are still there in the policy. Next week it will be.
It is the Easter for Monday. That is it. I'm striking
Because many matters are debated.
I'm striking that.
Is any matter?
88 also, that NI Act matter, we have discussed to dispose of make payment within a stipulated period. Mr. Jenaijan, I hope the supplemental list will continue. He was here up to 2 p.m. Let it come in supplemental list, matter can be disposed of. Directing
Tomorrow?
Yeah, or 88 in the supplemental, so that matter can be disposed of. That granting you some time to make payment.
You should have mentioned it if he's there.
It's already there in the weekly list.
Weekly list is there. Yes, sir, anything you want to mention? Want to mention anything?
My lord, I mean, 2.5 memo, but a compromise revision, commission revision. List is asking.
Compromise, we offense?
500, 294, the government servant, pension for me. Or appellate court also
Confirm.
Confirm.
So these are not compounding, I can't class it.
So family case.
They have compounded the offense, compromise after the conviction.
After conviction.
What is the use of it?
List
Because the government servant.
Government servant.
Trial court convicted. Appellate court also confirmed that. Now they've entered into a settlement. What is the use of that? I don't think.
Evidence of legal defect. Test out to hello. Test out to.
Yes. Anything?
Yes.